item 73, April of 2006. So that can be tagged into weekly.
Weekly.
Yes, 73. As so far as 74 is concerned, I have taken consent from the counsel for the appellants. They agree that it will be taken up after vacation.
74.
I
74.
have objection to that item 74 being put up.
Due respect, Mr. Rizvi said that comfortable today, my lords. So what I pray is let it be taken up some other day for vacations. And in fact, I have prepared the note and everything. So it can be heard and taken up, my lords. Can be disposed of.
You are talking about 74, right?
Yes, my lords.
Yes.
Then what do you want?
Yes, I was proposing to take up after vacation because some difficulty.
But he is
He is
opposing.
in difficulties. I have no objection for today. But it can be taken up any other day next week.
8th, my lords, then
We will try in the next week.
8th, yes.
8th, 8th, 8th.
Let us hardly half an hour, my lords.
Yes.
And I'll file the written notes of submissions.
Yes. Let it be 3 o'clock on 8th. So
Fine.
because the bail matter, the pressure has gone now.
My lords.
So we can hear it.
Yes, my lords.
75
Who is for the other side? Weekly. Weekly.
Which I mentioned CRLMC 2091 of 2022. My lords, this was in the list on Thursday. My lords, at the time of rising, had given the date for today, but it's not in the list. I'm praying if some date could be given.
Not listed.
What is the question matter where there's a settlement with the bank?
Was it directed to list?
Yes, my lords, it was item 93 on Thursday. At the time of rising, my lords had given today's date.
just has no order has been passed. So that's why I found out the file.
One more indictment.
There was some problem.
One more indictment is 3rd October or 7th October.
Huh?
If a date could be given, 7th or 3rd October, my lords.
Let it be 7.
I'm so grateful. So there's one more indulgence. Post class, I may kindly be accommodated.
Yes, definitely.
I'm so grateful. I'm so
Pardon your lordship.
Item number 20.
Item number 20, your lordship. Lordship kindly be taken up day after tomorrow, your lordship. Mr. Pal, question, your lordship.
Item
20.
20.
Yes, your lordship.
Let it come, you be here. I'll just see.
Pardon,
I'll accommodate, don't worry. But
pardon, my lord, CRLMC number 4561 of 23. This matter was in the list on 14/8/24. Your lordship directed to list this matter on 21/8, but till now that has not come, my lord.
just take it up. Huh? Take it up. We'll just take it up. Yes.
Pardon to mention, your lordship, item 28 of the weekly list, your lordship. Your lordship, in this case, substitution petition was allowed and we have filed the consolidated on 89, your lordship. Your lordship may kindly take up on next week. I humbly pray.
It is there in the weekly list. Get ready. Anytime I'll get the time, I'll hear it. Get ready. Let it be there. Don't worry.
I have also similar pair, weekly list
Okay.
item 187.
You get ready. Whenever I get time, I'll pick up. I don't go by the list. In the regular matter, after the miscellaneous matters are over, if both the sides are there, I'll pick up any matter.
Hearing matters.
I'm ready to do it, but after the miscellaneous matters are over. So I don't want to deal individually, Get ready and tell the other side also. If they are ready, I'll pick up any file. Any file from the weekly list and I'll start doing. But you make the other side ready. You tell them that I'm ready, please, written submission, whatever you have.
Everything.
So the other side also should be ready.
Book ready, written note.
And the other side should also be ready so that I can pick up that file. The moment,
Special assignment.
so that way we do it.
Pardon to mention, my lord. One bail application 663 of 4 of 2024. Since has been adjourned since July, not yet been listed, your lord.
Now all bail matters are listed.
No, it's adjourned by Justice A.K. Mahaprabhu.
We'll take it up. Bail matters, almost all the matters for one round I have taken
But
up.
not yet been.
Okay, this will be taken up.
Yes.
So we include this, Include this. Okay.
Okay.
Yes. Let us start.
Item 1. May please, Lordship.
Yes, sir.
Lordship, in the last occasion, the defect has been pointed. So I has been filed, I number 21 for dispensing the filing of certified copy. So which is
It's all right. You proceed now.
no, it may take. So I have been filed. So it may take an after vacation. So I have to-
No. Certificate. See, I have said that the petitioner has to cure the defect. If not cured, It will be automatically dismissed.
Yeah, all defects are cleared.
Okay, then argue.
So actually, the matter is, I'll be submitting the copy to the.
No, it's a matter that I'm holding copy. Sir, like the thing is that he was DA case of 2022 was challenged the DA case for quashment of the FIR. Yesterday was on the basis he has given bunch of document to Lordship can see. Let him submit that all in 22.
What is the stage?
So investigation is going on.
22.
22 DA case.
How many years you will take?
ଆମେ ମାଗିବାକୁ କହୁଛୁ ଅନ୍ୟ ଡିପାର୍ଟମେଣ୍ଟ କୁ ରୋକିବା ସେମାନେ ଆମକୁ
That a part, but how many years you will take? I'll charge it.
ଏବେ ଆମେ ଯୋଉ ଷ୍ଟ୍ରିମଲାଇନ୍ କରିଦେଲୁ ଅଲରେଡି ଷ୍ଟ୍ରିମଲାଇନ୍ ହେଇଗଲା.
Put it immediately after vacation. You seek instruction and give me a definite time frame.
What I suggest your lordship may also dispose of the direction. That's the pushing.
No, no, I can't take that. So you simply say that I can record it after put it after vacation.
Yes.
What I suggest, madam,
Yeah.
let him produce all the documents before the IO. Who will examine the IO? Can all the documents be examined?
No.
Otherwise, if he is the agreed one, he can approach.
What I propose to do is I'll dispose it up, saying that whatever defense, whatever document you have, give it to the IO. Let the IO consider and take the call. If any grievance is still left over, then you can raise the.
That will be better. At this stage,
That's better. That liberty also I'll give.
Liberty, okay.
And counsel for the petitioner has challenged. No, the present petition, petitioner has challenged the quashing of the FIR in Kotak Vigilance PS case number 15 of 2022. The precise grievance of the petitioner is that although the FIR was registered in the year 2022. But the investigation has not yet been concluded and the charge sheet has not been filed. Therefore, he seeks indulgence of this court. He further submits that the documents which he is relying upon is not being taken into consideration by the IO. At this stage, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to furnish all documents relating to his defense in the present case before the IO. This being a case of disproportionate
asset.
The IO is expected to take into consideration all the documents to be submitted by the petitioner.
In accordance.
And deal with the same in accordance with the law. With this observation, this petition is disposed of with a liberty to the petitioner to resort to remedy available to him under law if any cause of action subsist. Okay.
Deep note. Item 2 also same.
Same order.
1 and 2 same order. Husband and wife.
Deep lawless.
So you give all they will consider. If it doesn't happen, they file charge sheet again. You file
Yes, Lord.
both the matters. Yes.
Item 3.
Item 3.
Okay, compromise. Let counsel for the petition submit that the petitioner has met with an accident and hospitalized. Therefore, he is not able to present in the court. Hence, he seeks an adjournment and leaves the matter after vacation. Yes.
Item 4.
Item 4, prefer the password.
Password. Yes.
Okay. Item 5.
Yeah, please, Your Lordship.
Yes.
Before I address your Lordship, there has been an inadvertent error. In Annexure 1 series, there are actually 3 documents. Inadvertently, my lord, I have only one document, that is public analysis.
I want to file.
I have not filed,
If you want to file, okay. Let counsel for the petitioner seeks one adjournment to file. No, you file it. Sir. Oh.
And it may not be necessary, my lord, because I have quoted the complaint portion in the.
But you file it better. Let the additional document file additional document we can have 1 week. Let him do so by
In course of the day.
during the course of the day. Leave the matter. 8-9 दे दो 7-8.
But in this case, your lordship recollects your lordship. From the court of.
That it will not come, my lord.
I'll deal with the report also on that.
That's it.
Yes. Yes.
Item 6.
Please, your lordship. Item 6 I am there. Lords, here the petitioners have challenged an order of the learned JMFC at page 9 of the brief, my lords, taking cognizance on a charge sheet filed against them under 498A, 304B, 306, 406 by 34 IPC and 4 of the DP Act.
Yes.
Lords, this challenge is basically on the premise that, firstly, the materials on record in the charge sheet, including the FIR, don't make out the offences. And secondly, my lords, that the parties have entered into a settlement. That we have entered settlement is a corollary, my lords, of the fact that in view of the change in circumstances, my lords, the informant has come to realize that the death of the deceased was not at the abatement of any of these petitioners, and she voluntarily committed suicide for other reasons, my lords. On this basis, my lords, we challenge the cognizance, my lords.
Yes.
My respectful submission before your lordship is that the postmortem of the victim was conducted.
But just see, the informant has filed in para 2, he says the FIR in the present case was filed being instigated by some villagers who were inimical to the petitioner and his family members, and having now learned that my daughter who was ill had committed suicide by consuming the pesticide because of unbearable pain, deponent does not wish to proceed with the case anymore.
No, even if 304B is there, 306 is there. Okay.
They may be there, but my submission
Now, not
materials on record.
case cannot be quite malad. And so far, other ground they have taken malad. Last time, malad say mentioned that the matter has been compromised. This said, 306 cannot be compromised malad in view of the Dexaben case malad. And Rapis code held that 306 can be cast malad.
You respect me, Lord.
On merit malad, my senior man case on merit malad. But in view of the affidavit filed by the petitioner, case can be passed, my lord. And so he has in his 161 statement is there, my lord. That is submitted, my lord.
The same witness have said.
My lord, in 161 statement, there are allegations that such are parts are there, my lord.
Yes.
And the he stated that the petitioners might be committed her murder by pouring poison on her.
My lord, recently your lordship delivered judgment in a case. Dr. Priyank Tapuria versus
That is on merit, my lord, on merit.
On merits. Lord, my submission is that here also the objection of my learned friend that Dakshaben prohibits your lordship from interfering because of the fact that it's a case under 306. My learned friend has first show that the materials on record establish that on the basis of abatement of any of these petitioners, the death took place. If no abatement can be ascribed to us, how does Dakshaben be applicable, my lords?
Then on merit, but I was just thinking aloud, I don't know, I may be wrong. A statement given by a witness to the police under 161 CRP, vis-a-vis an affidavit given in the constitutional court, which will produce.
So far as the statement that a witness gives before the police.
That is recorded by police. It's not an evidence. It doesn't have an evidentiary value.
Statutorily, it has no evidentiary value.
Then you have an affidavit before a constitutional court given by the same witness.
Right, my lords.
How to go about it? Can you please help me so that I can write a judgment on this?
Then can your lordship keep it to some other day so that I can just...
So then there will be many problems, many issues in this if we can...
Lords, if your lordship keeps it to some other day, giving me that liberty, I will, my lords, prepare a small note showing the materials and how they don't make out a case, and also this aspect which your lordship said.
Because see, he is not giving an affidavit in the trial court. He is giving an affidavit in the constitutional court where the plenary power is to be exercised.
I agree.
And if he comes and says in the court So Gyan Singh also says that if you put someone to trial which is a futile exercise,
Right.
it also we can take into consideration. In that scenario, how will you address this issue?
That's true.
only 2 line.
I'm suggesting let it some out some other day.
Yes.
And
I will have 1 minute, Mr. Raghunath says.
2 line.
Yes.
ज्वाଇଁ मनोज भाई मो झील को धमकाई कहते तोटू अधिक सुंदर झील
Earlier bail application has been disposed of by your lordship. Earlier bail application has been disposed of by your lordship with the liberty to file with changing circumstances, my lord.
Liberty to?
File afresh, my lord, with changing circumstances, my lord. It was filed before charge sheet, my lord. And in the meantime, my lord, trial has been commenced, and out of 35 witnesses, my lord, 16 witnesses has been examined, including the informant, doctor, and the family members of the informant, my lord.
Yes.
And the vital witness, that is, my lord, the witness to the seizure, my lord, he becomes totally, that is,
Seizure in 302 seizure is not
my
vital.
lord, why I am saying, my lord, why I am saying there is no eyewitness to the occurrence, my lord, only, my lord, last in theory is there, my lord.
Where are those evidences?
I have annexed, my lord, that is, my lord. You also kindly see the pairs, my lord. Pairs, my lord, running test, my lord, 17, my lord, PW 3, my lord. The Bhagwan Sahu, who was a witness to the seizure of the witness, seizure of the
17.
witness, my lord. He has been done hostile, my lord. And my lord, the informant is PW 9, my lord. And the doctor is PW 14, my lord.
Yes. Yes.
The third time will come, my lord. He had supplied the evidence document, my lord. Almost 16 witnesses, 14 witnesses examined, my lord.
Let us the petitioner submits that earlier this bench had rejected the bail application of the petitioner. How liberty was granted to the petitioner to renew the bail plea on the changing circumstances. Subsequent thereto, evidence of about 16 witnesses.
Total 16 witnesses.
16
Witnesses have been examined out of 32 witnesses. 35 witnesses. He relies upon the evidence of those 16 witnesses and submits that no case is made out against him, and therefore he is entitled to bail. Mr. Raghunath submits that he would examine the evidence supplied to him during
And also CDR
address, then call for the CD as well. Release the matter after vacation.
before vacation.
Yes, after vacation. Yes.
Kindly.
Eight.
Not
Seven,
My lord, the case is under section 294, 323, 363,
Yes.
366, 376, clause 2, and 34 of the Indian Penal Code.
Yes.
Reduce section 6 and 17 of the
Custody.
custody since my lord, 20 April 2023.
April.
My lord, today April 2023, and the victim age is my lord 17 plus.
Yes.
During the time of affair, my lord, he only got his illness or the victim, my lord. They need his wife and husband, my lord, during that period.
Okay. Yes.
Notice sufficient one.
No, sufficient.
Notice
Yes.
sufficient one. 5.
164. Read 160.
My lord. But the
There are two matters signed.
my lord.
Yes. Yes, sir.
My lord.
Why this matter is going on for so many years?
206 kg ganja, my lord, for that.
So many hearings.
Carrying car, both the petitions are in
In custody since 6/10/21.
610,
but has come.
610,
21.
21. Yes. The report was sought for.
My lord, my lord.
Yes. What does it say? The conclusion of the current
Flag P. P.
4 prosecution witnesses have already been examined out of 9 shortlisted. So then 5 remain. The date was fixed on 8/8/2024. I'll give 3 months. 3 months to record the deal completely. 3 months because recovery is also. See, I'll tell you. See, 4 witnesses have already been examined. 9 shortlisted. 5 remain. In that is this is the report up to 30th July.
Lordship, I kindly see order dated 79.
79.
No, no.
79. Yes. Yes, sir. Yes, read it out.
For that reason, my lord, earlier occasion, my lord, the court held that it state unable to obtain the status report. For that reason, status report again.
Right on. Pursuant to the order dated, status report order dated.
You have to read.
Na, see, status report, see. Court mage dele. No, and level.
Pursuant to the order dated 26/7/2024, a status report has been submitted by the Court of Additional District and Sessions Judge, Special Judge, Jaipur. And in the status report, the Lieutenant Court below has informed that out of 9 shortlisted prosecuted witnesses, 4 witnesses have already been examined. The hearing date was fixed on 8/8/2024 for the trial. In view of the report submitted by the Additional Sessions Judge, Special Judge, Jaipur, dated 30th July 2024, I am of the considered view that the trial court should do well to see that the evidence of all the witnesses, all the 9 witnesses, should be recorded by court below as expeditiously as possible, preferably within a period of 3 years. Thereafter, the petitioners are given liberty to renew their bail. If such bail is filed, the same shall be considered on the basis of the material available under court then.
3 months is too long. My lordship, not 1 month.
No, I don't know what. You see, you know the trial. If this is unrealistic target, then it will be difficult. And they will move the application will take another 15 days to be listed. Once it is listed, I will extend it, obviously. And in that process, again, 4 months will be over. Better than 3 months you give it.
200 are there, my lord. Dasara and summer.
Let it be 3 months. Realistic. And there are a lot of holidays now.
Dasara and
Dasara, Diwali and all.
December also, my lord.
December, so don't.
Chaudhary judgment also.
What is he saying? We have some problem. 9. We have some problem. Already passed the order. Yes.
Second place.
Okay, same.
There are two items. Same there are 2 cases, my lord.
2 cases, same FIR.
Say Jani par, same FIR. Jani par.
There is some problem now. Either here, I think we have a problem. Yesterday also we had 3 matters like this. And all these are
technical man.
गाली भी मैटर क्या है ठीक है जी बहुत सारा जैसी
Mr. Panda.
No, for local I think it's same, but from center there are some problem.
So center
there are problem. Just tell me, I'll speak to you.
And both the cases dispose of.
Yes, 10. Recovery. Recovery how much?
Recovery matter 1
quintal 42
kg 200 grams.
Yes.
My humble submission is that matter he is in custody since 24 September 2023.
24 September
2023.
Yes.
And charge sheet submitted matter 22/3/2024 without chemical exemption report. The investigation agency submitted charge sheet matter. I feel that matter trial has not been commenced.
Okay. Vice Chancellor submission. Right. Petition is agreed by the order dated 3/10/2024 to 3/10/2023, whereby his bail plea has been rejected. Subsequent thereto on 22/3/2024, charge sheet has been filed. Then consequent the petitioner submits that although the charge sheet has been filed, but the chemical examination report has not been placed pleased by the prosecution. Mr. Rahul, on the contrary, submits that the chemical analysis report is already available.
Yes,
Is
ma'am.
already available. In view of the aforementioned changing circumstances, the petitioner is given liberty to renew the bail plea before the trial court. If such bail plea is removed, the same shall be considered on its merit on the basis of the material forms part of the charge sheet. With this liberty, the petitioner is disposed of. Next.
One line maybe also, madam, since 7th June 2022, the chemical examination report is not available in the court below.
Now, the judgment of Justice R.K. Patnaik. Once it is there, then even if you have got the interim bill, that will be called up. That's the problem. So therefore, don't press for it. Okay. Yes.
May I please address? In this case, madam, the petitioner, is in custody since 22 April 2023, 28 28 July 2022.
24.
28. 28 July
28 July 2022.
22. My lord, till yet, my lord, trials have not been commenced here, which is the last order 2024.
Yes. The report was sought for.
There is 120 quintal, 27 kg, my lord.
120 quintal, but my lord, the petitioner no any criminal and local person.
No local person.
And custody since 2 years, 1 month, 26 days.
What is it saying?
Last August, 18 September, last August.
It means produced. In the NDPS cases, all PWs are under the control of the police. Why they are not appearing?
That I have to take instruction.
See, the last order is accused is produced through VC from Central Jail. No PW is present. And the report, the last report sought from this court was 6th January. The charge has been framed on 13th of 2023. Thereafter, today we are in December and we are in virtually October. 10 months. You not examine any witnesses. What is this?
We'll take instruction and let your lordship.
Right on. The pursuant to the order dated 19th December 2023, the Court of Additional Sessions has come special Judge Koraput, while its report dated 6th January 2024 has intimated this court that on 13/12/2023 charges have been framed. And the trial has already commenced. The counsel for the petitioner has hands up the proceeding dated 18/9/2024. Perusal of the same indicates that till 18/9/2024, no witnesses have been examined. Despite the fact that the charge has been framed in December 2023, even after lapse of 9 months, no witnesses have been examined yet. Yet the petitioner is in custody since 28/7/2022. In that view of the matter, a fresh report is directed to call for a fresh report from the concerned trial court and release the matter on 8th or 9th. If it is, if no witness are examined, I'll enlarge it. He can't wait for 1 year. You won't examine.
Item 12 has been brought on adjournment.
Adjourn? Why?
Senior.
What is the offense?
My lord, offense is under 302.
Okay, so after vacation, they do adjourn. On request, we'll go to November, December, whatever. 30. December.
item 13,
Yes.
the please your lordship, item 13, refer after vacation lordship.
Sorry, adjourn.
Refer after vacation lordship.
What is the offense?
My lord, 1 quintal 75 kg ganja.
Oh, on request adjourn. ठीक है.
Item 14. May I please for your lordship? My lord, the case has been committed to the Court of Session since February, my lord. The custody since, my lord, custody since, my lord, 31st July 2023 on. So, allegation, my lord, informant Ajay Deuri, the elder brother of the informant, Vikram Deuri, was sleeping in his house at the time the present petitioner abused. Ajay Deuri, suspecting that he is practicing witchcraft and assaulted by means of an axe. Now, thereafter, the 27 of the Indian Evidence Act has been recorded, and on this confessional statement of the petitioner, he has been implicated as an accused, and the petitioner also called the 108 ambulance and shifted the injured to the Banswal hospital. The medical officer declared him dead.
Yes. Chubby, what is his name?
Chubby Deuri.
Chubby Deuri.
My.
What are the evidence against him?
My lord, there are eyewitnesses are there, my lord. And yes, my lord. Yes.
Statement of one eyewitness.
Yes, my lord. My lord, ମୁଁ ସନ୍ୟାରୀ ଦଉରି relevant part, my lord.
And last occasion, Lordship called for the report from the lower court.
Yes,
that,
yes. I just. Submitted that. The case record was received by this court on the behalf of counsel for the charge against the September. Thank you. Thank you. The report is you have been already acquitted.
Lordship?
You have already been acquitted.
My lord. I
You
have
don't-
filed a memo for Udra.
Withdraw. That's what happened. You acquitted, eh? Withdraw. Memo is. You file a memo. You file a
Yes,
memo.
yes,
You
I
have
filed.
the client has already been acquitted and he is set free. Yes.
Lordship.
May I please your lordship? Admittedly, there was no eyewitness to the occurrence,
Yes.
but basing upon the suspect, the petitioner is in custody since now 10, 19/9/2023.
Sorry, 19?
9, 2023.
Yes.
Yes. My lord, father of the petitioner informant was left the house in 2024. On 15/9/2023,
Dilip Maji.
I am for Dilip Maji,
Yes.
one of the accused.
Yes.
Mohan Bhai was the informant. The father of the informant was left the house on 14/9/2023. The namely Baishakhu Mahaling, who was last with the
What happened to the other accused persons?
they are in custody. Matlab, they have
How many? Two of you. Three.
there are two accused.
Yes. And what is the
Yes,
evidence?
my lord. Here, my lord, after last time here, my lord, that just ଆଜି ତ 20 ଏବେ ମଗର ଦଉଛି 14 ମୁଁ ଘରେ ଥିବା ସମୟରେ ସମ୍ବଲପୁର ଗ୍ରାମରୁ କୃଷ୍ଣଚନ୍ଦ୍ର ବୋଇ ଆଗରୁ ମୋର ପରିଚିତ କୃଷ୍ଣଚନ୍ଦ୍ର ସେ ରାଜନଗର ଗ୍ରାମରେ ଜମି ଚାଷ କରିथा ବସ୍ ପାଖକୁ ଆସିଲା ତାପରେ ଆମେ ଦୁଇ ମିଶି ମୋର ମୋଟର ସାଇକେଲ ମଧୁ କର୍ମୀ
I thought that you are requesting me to recall that order. Yes.
Item 19, my lord, I'm in the custody since 5/6/2023, my lord.
5/6/23.
Yes, my lord.
Yes.
And my lord, charge sheet was submitted on 25/9/2023.
25/9, huh?
Yes, my lord.
Yes.
And my lord, the present petitioner is Subhas Naik.
Subhas Naik, huh?
My lord, in this case, there are two allegation number 32 and 34 of IPC, my lord, and 120B. My lord, so far as evidences are concerned, my lord, there are two eyewitnesses in this case. One is Radha Naik, one is Sukanta Naik. My lord, Radha Naik's, my lord, 161 statement is at running phase number 58, and my lord, 59. They have already been examined, and I have filed the certified copy of the deposition, and
Not supported.
my lord, they have changed their versions, my lord.
Changing something, supported or not?
My lord, they have supported. But so far as implication against the present petitioner is concerned, my lord, there is no specific.
Yes, against type what you have.
Madam, page PW3 man, who is the one of the items?
PW3 and PW8.
Yes.
PW3, para 2 man.
Okay.
Para 2, last line man.
1 minute. PW3.
PW3 man.
Yes.
I and my family members rose to the spot.
Which paragraph you are reading?
Madam,
Para 2 last.
Last, okay.
that
Yes.
accused persons assaulting my brother by means of sword and other deadly weapons. Seeing us, they fled away from the spot on a scooty and on a motorcycle. I have seen all the accused persons. We took our brother to the hospital. That is the PW. Then my PW8, who is one of the eyewitness, Radha Naik.
PW3 and 8.
PW3 and 8.
8 also my last para 2 last 2 lines.
Yes.
I saw that all the accused persons who are standing in the dock.
1 minute. Let me go there. Okay. PW8. Yes. Yes.
Last 2 line, para 2 last.
Para 2 to them. Yes.
I saw that all the accused persons who are standing in the dock
Specific.
are asking Kalia by means of deadly weapons such as sword, bhujali, chapor, etc.
Yes.
Well, a specific allegation is not there against the present petitioner. And if my lord may forward,
That's all the
all the accused person, my lord, in 161, they say that all were there except me, my lord. If my lord may come to running page number 58, if my lord may come, the same, I
You have confronted with this witness.
my lord,
All these 2 witnesses have you confronted with 161?
my lord, they have been
Now 161, the relevancy of 161 goes once the evidence has come on record.
Yes, my
You
lord.
show me from the cross examination whether you have confronted this matter
They have not.
and you show me that. That don't read 161.
But that part,
Then you are gone.
but so far as overt act is concerned, my lord, that
See, 161, you are relying upon 161.
my lord, even if my lord, Caesar of the said, my lord,
How to get out of the evidence of either those who have implicated you? From the cross examination of PW3 and 8, you
cross-examination,
otherwise you have to go and try there only.
my lord, cross-examination, it has,
What is the use of 161?
my lord,
You should have confronted. You have not confronted that.
lordship may keep it to after.
No, not keep. See, better you go to trial court because on 14th August 2024, this evidence has been recorded.
Yes, my lord.
And your bail plea was rejected. Your bail plea is rejected in March 2020.
My lord.
So you go there, right up. Petition rejected
Well, after vacation,
order
also-
dated 14/3/2024, whereby his bail plea has been rejected. Subsequent thereto, the evidence of the witnesses have been recorded, particularly the evidence of PW3 and Co, which has been recorded in the month of August 2020, August and May 2024, implicates the present petitioner. In view of the fresh materials which have come on record in the trial court, before the trial court, I am not inclined to enlarge the petitioner on bail at this stage. However, the liberty is granted to the petitioner to renew the bail plea before the trial court. Right, for such bail plea is moved, the trial court shall consider the same on the basis of the material available on record.
And recent development, my lord,
Available record.
recent development of
Within 15 days. Within in such application. Yes.
Madam, so you PW 3 and 8, madam.
3 and 8, yes. Particularly P 3
Three and
yes.
Item 20.
Yes. Yes, sir.
Lordship, item number 20 can be taken on day after tomorrow, Your Lordship.
Either you argue or it will go to December.
Lordship, Mr. Pal is not.
You will decide the date. You will not decide the date. Either you argue what is the case, you may get the bail. Why are you asking for adjournment? Let us see.
Lordship, it is a case, Your Lordship, 21, 42, 34, 406.
20, then argue, you may get bail.
Petitioner is dealt.
What is the material?
Madam, this is against the Republic of India.
CBI.
Notice was issued or not?
Madam, it has appeared. Mr. Naik has appeared.
Yes. Yes, Mr. Naik.
Your Lordship may kindly come to order.
He is asking for an adjournment.
Any date in December will suit me.
Soon, December suits him. Is there any material against him?
A lot of materials, Your Lordships. I will take half an hour. Let it come in December, Your Lordships.
No, this young man is arguing, if there is something we will see, consider.
Let him
See, I am
argue,
not shooting, I am just considering the bail plea. If is anything there, I will grant bail.
Let him argue, Your Lordship. If something is left, Mr. Pal can add in
You
December.
argue?
Your Lordship, kindly I just need something.
I think they also know that they don't have a case, it seems.
He knows it, I think, Your Lordships.
On request, yes.
21.
When is it listed, Your Lordships?
After vacation, we will see. Yes.
Lordship, kindly do it for tomorrow, Your Lordship.
No, we don't say that. You will not decide the date. How difficult it is to get listed, you know. I am planning in such a manner that all the matters will be listed.
5 years, Your Lordship.
You can't decide the date. It is listed, argue it. Otherwise, it will go, he is telling December. Still, since you are appearing, I am putting it immediately after vacation. Beyond that, nothing. Yes. Other classes, if you want to argue, I am ready.
Your Lordship, kindly pass it over, Your Lordship. I will let.
Pass it over. Mr. Naik, he is seeking a passover now.
Let him, Your Lordship.
List it after vacation.
Okay, yes.
Taking a half an hour. Yes.
21.
20. Your Lordship. Yes.
Your Lordship, this petition was custody since 27/10/2024. 2024.
24. Yes.
2014 years. Sorry.
What happened?
2014 years.
1-4. Okay.
And in this case, maximum punishment is Your Lordship 10 years.
What are the offences?
Offense, Your Lordships, 420, 406, 409, 467, 468, 471, 180B.
What is
POD Act, Your Lordships.
What happened, my lord? Present petition involving series of cases, my lord. And though in this case, my lord, case that is not with me. I have to authenticate the rebut. Rejection order shows, my lord. This case are at fact end, my lord. Consider witness, my lord. 15 has already been examined.
No, it's all right, but 2014.
No. 2014 has a number of cases, my lord. Not this case.
I am talking about this case. Number of cases we will deal with that.
My lord.
2014, October 2014 till today. This is about a decade. How can you keep him? I am granting bail, nothing doing. This is atrocious. You can't do that. He may be involved in 1,000 cases. I don't bother about it. But 10 years, somebody's liberty, you can't take it like this.
In this case, my lord, he was arrested in
27/10/2014, he says.
He was arrested in this case, my lord.
You still that in this case, custody from which date?
In this case,
he may be in custody in some other case. But in this case, if he is custody for more than 2-3 years, I'll grant.
Let me, in this case, let him say, Lord, well,
in this case,
Your Lordships, Your Lordships, I am
you are involved in many cases.
Yes, Your
You may be in
Lordship.
custody.
I am showing, Your Lordship.
Show me. Yes. Pass it over, huh?
Yes, sir.
Pass it over, just check it up, tell me.
Yes, sir.
No, he has also to be, you know, he has also, see. I'll just pass it over, just see. If you,
27/10/2014. Yes, sir.
this is the FIR, huh?
This the
Have you checked it? Just check it up. Because this is, I'll just pass it over, just check it up. I'll just pass it over. Yes.
22 May appeal, Lordship. I am VC, Lordship.
Yes.
Last occasion, Lordship granted bail, but inadvertently, paragraph number 4 of the order sheet, the wrongful as additional session judge come special judge come under POCSO Kotak instead of additional session judge Nimapada. Paragraph, yes, Lordship.
Order rated 13(9).
Yes, Lordship, 13(9).
39, which paragraph you are talking about?
Paragraph number 4, Lordship.
Para 4. 9 I have said incision record. Yes. Para 4 change kar diyo. Kotak, instead of what? Kotak?
Instead of additional session judge Nimapada.
No, 4 number paragraph में लिख दो Nimapada. In place of Kotak.
It's a special will लिखा जीवन खाली लिखा जीवन session judge Nimapada.
The additional session judge come special judge is not required.
Not required, Lordship. Additional session.
Yes.
Additional session judge Nimapada.
Acha. Additional session judge come special court under POCSO Kotak. Additional session judge Nimapada at para 4 of order dated 39/2012. Okay. Thank you.
Obliged.
Yes.
23.
Yes, sir.
My lords, charge sheet submitted on 8/2/2024, my lords.
8/2/2024,
my lords, and petitioner is custody 10 months, my lords. His date of custody is 19/12/2023, my lords.
Right.
Main offense, my lord, 376(2)(n) along with
Yes.
no POCSO is there. Consensual relationship between major person.
What is the age of the victim?
22, my lords.
Yes, sir.
This is custody since 18/3/2024.
18/3?
2024, my lords.
18/3/24.
Alleged offense under section.
Yes.
302(120)B and 34 for Odisha prevention of witch hunting.
Already charge sheet already filed. On the basis of conference section of the person have been arrested. And no specific allegation against him.
Yes.
Rejection order is my lord on 18/4 and charge sheet was submitted on 14/7.
See, why have you moved application one petition? Role of different accused may be different.
Again, this rejection order
ଆପଣ ଅଲଗା ଅଲଗା କରି କରିଥାନ୍ତେ ନା ଆଉ ଯାହାର ରୋଲ କମ ଅଛି ତାକୁ ଆଗକୁ ଆଣିବେ ନା ଆପଣ
ସେମାନଙ୍କ ନାଁରେ କୌଣସି ଆଲିଗେସନ ନାହିଁ ସେ ଗାଁ ଗୋଟେ ମିଟିଂ ହେଲା
you repeat your bail please separately. See all of them 9 accused. I have to see what is the role of every accused. Right? Satisfied on?
Well, charge sheet was submitted on 14/7.
14/7, huh?
Okay.
Your bail rejected. Your
18/4.
petitioners are 9 petitioners. There are 9 petitioners in the present petition. They are agreed by the order 18/4/2024, whereby their bail plea have been rejected by the court below. Subsequent thereto, on 14/7/2024, charge sheet has been filed in the present case. In view of the changing circumstances, petitioners are given liberty to renew their bail plea before the trial court. If such bail plea is filed, the same shall be considered on the basis of the material form part of the charge sheet. With this observation, the petition is disposed of. Yes. Let us know. I'll just.
ଭାଇ ଏଇଟା ଗୋଟେ
କାଲି ଗୋଟେ ଲେଖିଥିଲ ମୁଁ ତାକୁ ପଢି ପାରିନି କିଛି ସେପଟେ ଖାଲି ଉଣେଇଶ ଜଣଙ୍କର ଗୋଟେ କେସରେ ପଳେଇଲା ନହେଲେ ଅଲଗା ସମସ୍ତଙ୍କର ହେଇଥାନ୍ତେ ତାକୁ 9 ଜଣଙ୍କର ଏକା ସାଙ୍ଗରେ କରୁଛନ୍ତି କିଛି ନାହିଁ ତ ଭଲ ଅଛି ଭଲ କରୁଛି ଚିଠି ନାହିଁ ମାନେ ମୁଁ ଏବେ ଇଏ କରିବି ଆଉ ଯାହା ଚିଠି ଫିଠି ଯାହା ପଠଉଛନ୍ତି ତାକୁ ଆଉ କିଛି ଦେବିନି କଣ କୋଉଟା 26 ନାହିଁ ବା
No intention is there. No offensive weapon used, my lord.
How that?
No, I finished only, my lord, compound confidential statement.
Okay.
See, actually, this is first misbehave the daughter of the deceased.
Petitioner misbehaved the daughter of the deceased.
It is 2 months petitioner. Petitioner misbehave the daughter of the deceased. Then in market after the taking the drinks, they both quarrel there, and then disturbance between both the occasion. After the return at the poultry farm, again they quarrel between themselves.
Right.
And when deceased was returning to her home, at the time from backside he hit him. No, on the conflict, he made him thrice and four times, for which bleeding, and he died at the spot.
That portion.
Yeah.
Simply, he pushed it and he fell down. It hit in the concrete and
Yes.
but thereafter also he has tried to do something.
No, thereafter nothing.
In that portion.
27 himself.
Yes. And there is no eyewitness.
No eyewitness there. But last thing is there.
Last thing is he was all right, but he is not killed. In fact, he was not.
That's why I was thinking that after that Handia ପିଉଥିବା ବେଳେ ଅଶ୍ୱିନୀ ପ୍ରଧାନ ମତେ କଣ ପାଇଁ ମୋ ଝିଅକୁ ପାସ୍
leave that part, the incident part.
ହଁ ମତେ ହାତରେ ଅଶ୍ୱିନୀ ପ୍ରଧାନ ଜୋତାରେ ବାଡେଇଥିବାରୁ ମତେ ବହୁତ ଅପମାନ ଲାଗିଥିଲା। ଅଶ୍ୱିନୀ ପ୍ରଧାନ ମତେ ଗାଳି କରି ଯାଉଥିବା ବେଳେ ମୁଁ ତାର ପଛେ ପଛେ କିଛି ବାଟ ଗଲା ପରେ ପଛପଟେ ଧକ୍କା ମାରିଲି, ଯାହା ଫଳରେ
Ideas. But the forwarded under section 373 and 34 IPs. This petition is another.
Custody since?
Custody mailed 19/3/2024.
Only 3.
I pray mailed kindly 21. My rejection of can see my
21. 21?
21.
Yes.
Third para my lord.
Yes.
The observation of the Lord trial court my lord during course of investigation.
Where is that?
Third para my lord.
Yes, read it.
During course of investigation, each and examined and their
Third paragraph.
third paragraph, my lord.
Page 21. 19,
Last
20, 21. Yes.
Right.
Yes.
During course of investigation, each and every laborer were examined and their statement were recorded, which are available in this record. The statement of victim is also recorded by the investigation officer. This statement witness corroborate the prosecution case entirely. The mobile phone used for videography is also seized from the possession of petitioner Vipanjari Dilip Kumar. The aforesaid facts are clearly see another main accused indicating that the petitioners and others named above have tactfully persuaded the laborers. All of them contributed their mind and body for trafficking of laborers towards Dalampeta, the village of the petitioner Vipanjari Dilip Kumar.
What do you want to say?
I am coach. After arrival, all the laborers at Dalampeta, they were subjected to extreme physical and mental exploitation. Thus, prior test materials under section 373 IPC well made out against the petitioner Ghasiram Harijan as well as the petitioner Tikulal Duria. The made out against the petitioner Vipanjari Dilip Kumar and his brother V. Bonchi Krishna. This petition only 3763 my lord. Charge sheet also submitted 376.
No, 376D is also there.
Against another person my lord. Against my lord of Vipanjari Dilip Kumar and his brother V. Bonchi Krishna. In his one system.
That's prima facie material under section 373 IPC is well made out against the petitioners. Similarly, prima facie case is so is made out against the petitioners so and so. Okay. Yeah. This is the rejection of bail.
161 statement of the victim, 164 not available with me.
When the charge sheet was filed?
Charge sheet filed on 15/5/2024.
Yes.
Observation also same, my lord, in the charge sheet.
Observation, this is the time of granting. Yes, what do you say?
164.
For offense under section 420.
69?
6/1 2024, your lordship.
Yes.
6th January.
Yes.
Then 24 for offense under section 420 to 94 and 506 of IPC, your lordship.
Yes.
It is alleged in the FIR that the present petitioner has taken 97 lakhs from the informer to sold his land. Since 2010 to 2018, within that 8 years,
96, 7 lakh rupees you have taken.
Yes.
For selling a piece of land.
yes, Lordship.
Yes.
This much is allegation in the FIR.
There is
And after 6 years,
an agreement to that effect.
no, my lord, there is nothing, agreement is not there. And after 6 years, when the present petitioner is entangled with another and in custody, this informant has lodged this FIR.
What happened to that case? You got bail.
Yes, Your Lordship.
Yes.
I got bail from this and court. And in the FIR, the informant did not choose to disclose that she has taken one land from me in the year 2015. Got registered on the Annexure 3 series, I have given the sale deed.
What is your case is towards that money which you have taken, you have already given a land.
Yes, Lordship.
That's your-
Yes, Lordship.
What is it?
In this case, Lordship, petitioner have accused petitioner have no local.
Yes, Lordship, may I interpret this, the coordinate bench directed my learned senior to take instruction regarding the genuineness of salary by the EC, which has been given by For that reason, last occasion, your Lordship adjourned the matter and we used to direct for issuance of notice.
The order dated 21/6.
Yes, Lordship.
Let me understand who is saying what. I am not able to understand. He says something, you have to understand what is exactly has happened. Last day on 26/6/2024, there was a direction of the coordinate bench that the genuinity of the document in Annexure 3 has to be verified. 3 and 4. Have you verified it?
My lord, for more than 5 times I have contacted with the IIC that yesterday he has sent a instruction. That document he has sent to the sub-register for verification. But my lord, after serving the notice to the informant has made a phone call to me that a notice was served by the police. So what will I do? But you appear through advocate. That was the direction. Then my lord, I have asked that though land was sold in 2015, why have you lost FIR in 2023? Whether his land was sold or not. She told me that yes, I have land was sold, RST was there, and I have also get ROR also I have get. But what is her allegation is that which land was visited by that
other land has been given to him.
That is only the allegation.
Let me ask in this case, Lordship, the material document as which I kept it, but I will file a written objection and
What written objection will be in case of one land, he has given some other land. I am granting bail to deal with that.
in this case, the petitioner, the accused petitioner sold the property, right, plot number.
He has given some other land.
And that property has been mortgaged by the bank. So in this case,
I'm sending it to mediation. I'll grant bail and send it to mediation.
Because husband has been died regarding that issue, Lordship, and based on also husband is died, Lordship. I will file a suit also. No, because I'm not, because the suit and the property was right, no right of the property that
Follow what you're trying.
because in 2014, while the rights owner, the owner of the property has filed a suit, and the notice has been starting bottle in 2014, and he very conveniently and knowingly, and he sold the property in 2015. Because that is a judgment, civil court judgment,
What is the name of the accused?
and he is the accused number 3, Lordship, with the kind of number 24, Lordship.
What he's trying to say is 2014 there was a suit against you. You are the defendant number 3 regarding the same plot. Despite the fact that the suit is pending, you have sold the same property to him.
in 2015, your Lordship, my lord.
What is your answer?
That land was mortgaged by the informant before the bank.
What is your answer to this? Who was pending? What is property?
No, he's saying government has been pronounced, he's saying.
Yes, that's what I'm.
I have to take instruction, your lordship. But that land was mortgaged before, after verified the veracity of yes.
What is the decree then?
That is what we are
Decree also has been calculated.
What else is a decree?
The property, the food and the same is allowed to export against the dependent number 1 and 2, 3, but without any count, the RNG number 2960 dated 48 law and the other in respect of Khata number 82/48, plot number 70, that has been sold. That the complaint is sold to the complaint, the accusation sold to the complaint. Plot number 70 under Mauda Damodar is declared as the illegal void.
Then there is a problem. There is an injunction and declaration against you. Insofar as so which is the land? You are talking about the land.
Land is plot number 70.
Plot
number 70. Under Mauda Damodar, Khata number 82/48. Area 75 decibel.
Yes. There is a problem. There was an injunction against you and coupled with a declaration.
And 2000.
And despite the injunction and declaration, if the plaintiff Joginder Sundara and Upendra Sundara has obtained that. And despite that, you have sold it. That's what the case is.
I am inside custody more than 9 months, my lord.
Verified. He is entitled to. You verified. Give the copies to both of them. List it after immediately after.
So I will file objection, written objection. It will be
file it, but I am making it clear that last opportunity.
Yes, sir.
Because in a bail matter, I can't decide the title of your.
Yesterday, Lordship, the complaint instrument to, and today, Lordship, I approve.
Within 1 week, you do it, and immediately for reopening, this matter will be heard. And despite all these things, if you have taken loan and all, then he is entitled to bail.
No, Lordship,
and he sort it out somewhere.
Lordship, in this fact, in 2022, Lordship, judgment has been passed, Lordship.
Why are you mortgage then? Because you are the cheated the bank.
Because I knew all this thing. Why are you going to the bank? After in 2022, Lordship, I came to know that the judgment 2022, you are a loan or not. In 2024, I came to know that property already
I'll tell you, what I'll do is I'll grant bail and send you to mediation and sort.
I will show you because my father was my husband died in that.
File objection first day in the reopening. First day. Yes, next. 30. For opposing party to do and 1 week time to file response. By your last opportunity, one is granted. Leave the matter on the first day of so. What is that date? 26. Yes. Yes. 30.
Madam Madam, petitioner has been custody since 26/4/2024, madam.
26/4/2024. Yes.
Operation decision from the from the filed a mistake madam for informal madam. Mother is seriously ill madam. He is suffering from cancer madam.
And 306. Your custody since 26. You are the husband.
Madam.
You are the husband. Okay. You are the only accused.
Madam.
Show me the evidence. How is your wife died?
Madam, suicidal.
Show me that. That portion. Forget about your interim bail. Satisfy me on if you are entitled to regular bail, I'll grant regular bail. Yes. Which portion, sir?
Cause of death.
I read the entire.
No, last madam.
Yes.
Cause of death, madam.
Yes.
Mentioned display as a result of antenatal suicidal in nature, madam.
Procedural nature and,
My lord.
and statement of any witness.
Statement, all the witnesses, my lord, omnibus allegation में 12 वर्ष पूर्व वगैरह चला after 1 year the petitioner started picturing more demanding more dowry.
Yes. Any eyewitness?
I think so, Your Honor.
Show me something that she has committed suicide herself by bolting door or something.
There are no specific statement to that light, my lord. I'll be medical report, my lord. Your lordship,
What about medical? I am talking about the main.
my mother was do something like that. No, no, my lord, one thing I'm something. My mother
I am struggling to give you the regular bail. You don't assist me. Interim bail, interim bail. What interim bail? In 306. If you are entitled to regular bail, take the regular bail and go. Read it and come tomorrow. Assist me properly. I give you regular bail. Why are you insisting for interim bail unnecessary? You don't understand. You people don't read. That's the whole difficulty. You show me only one thing. If she has committed suicide herself,
my lord,
you are already in custody for such a long time. I'll grant regular bail.
my lord,
Read it and come properly. Tomorrow. Friday. Read it and come and try to assist me on regular bail.
my lord.
Just forget about see in the interim bail. If you say then I'll
No, I
will verify the.
no, my mother was admitted in hospital. 24/4, she discharged. And 25, my wife
You want to verify all these things?
No.
It will take 10-15 days. After vacation, I'll take it up.
No, my lord. They have to 5 days, my lord.
You don't understand the. Yes.
31.
Please, Your lordship.
Yes.
I am in custody since 29th April 2024.
29 April.
Yes,
29/4, my lord.
24.
24.
Okay. Yes, sir.
Offenses are on 1B of NDPS Act, 170 gram.
170 gram brown sugar.
That's it.
CD is there.
Whatever CD is, but final pure is not which.
Final here. Call for.
That's it.
Let him.
And
call.
the order
Next
dated
week.
8.
Next week.
That's it. Kindly have it.
Yes.
The order dated 8/8/2024.
Uh-huh.
When it was with the coordinate bench, Lordship has directed to verify whether the subsection 5 of section 5 of NDPS Act.
Yes, verify that out.
No, no.
50 plus 5 is complied or not. The last order, that is 8/8/2024, he has not read it itself. I put it
Order is not.
he put it next week. Next week, just see 8/8/2024, the coordinate bench has passed this order. It is stated by the land council for the petitioner that the section 50
No, that's it.
clause 5 of NDPS Act has not been complied in this case. To verify. Take to short time to verify this aspect. Yes, please.
Lordship, it is crystal clear from the charge sheet that
Let him verify. That's it. Order.
But the record shows that my 50 was it was complied, my lord. Section 50 was complied.
subsection 5, it was only one witness is there. Lordship, having
If you are verified, you tell me. Don't, I am putting it next week, please verify, because there is an order of a coordinate bench.
Right.
You can't casually simply say that. I have to deal with that. Okay? 32.
32 deeply.
Yeah. Mediation, settlement.
Lawyer, mediation, your lordship had sent it to mediation.
Uh-huh.
Last day for the mediation, he had paid 2 lakhs. Now there's a huge amount outstanding. By this time, he has paid only 50 lakhs. He has paid 50 lakh out of 49 lakh. He has paid 50. So I was, well, I had a suggestion. 27th, he is appearing before the mediation again.
Yes.
To finally say in what installments he will make the payments of the balance amount.
I will extend the interim bail and you sort it out and give grant.
My is accepted for 23rd October.
23rd October.
And so my Mr. Policy was.
What is the recovery proving from the charge sheet? When the charge sheet was filed? Charge sheet filed? When? Charge sheet filed. When? You should be reading with the dates and all, but no documents are provided to me. For me, application to see having a hearing.
Unclear now. The network तो ये खूप सांगितलं हाँ हाँ कॉल करायची हाँ हाँ कसा सात you सांगितलं
Yes.
Yes, sir. Okay. Now, after that, you have made it thrice.
No, no, six times, Lord.
Therefore is anticipated.
One in Orissa, other five in different states in that. The man of Jammu Kashmir, one Jammu Kashmir, one UP Millard, one Maharashtra, like. Not only married Millard, one state Millard. He is not a doctor, he is a partner. He is a kind of legal surgeon. Accordingly, Millard, then direct number of person and Millard saying Dr. Blower also said to the MCI, that's all 11 Dr. Blower thing, all natural fake Millard, said to the MCI Millard. I think for the letter Millard. And Millard,
And you have recorded the statement of all the.
this statement here, I am married to 6 persons, these are the statements Millard, I have some terrorly.
No, Pella, this is the doctor.
No, just get it.
Your investigation, kindly see your investigation.
Let the witness be again.
My 5 out of 18 witnesses, 5 witnesses have started, including his wife.
Witnesses, when witnesses were there?
For a second.
When the witnesses were there?
5 witnesses have joined. None have stated that he has prescribed any medicine to others. Or she has any activities along with as my brother setting that along with Pakistan
dated 13/5/2024, whereby his bail plea has been rejected. Subsequent days to the evidence of some witnesses have been examined in the month of July 2024. July 2024. In view of the aforementioned development, petitioner is granted liberty to renew the bail plea before the trial court. If such bail plea is moved, the same shall be considered on the basis of material which has come on record. Yes.
My lord,
40?
my lord,
I have given you liberty. See all the correct subsequent to your rejection of bail application. You renew the trial court will look into it. I am not here to see every evidence.
my lord.
You renew the bail plea. The allegations are so serious. Yes. 45. 45. Yes, sir.
In this case, offense under section 341, 323, 307, 506 and 34 of RPC.
Yes.
But the petitioner is an old man, aged about 61 years. He's been in custody since 25 2024.
24.
25 2024.
Yes.
The allegations against the petitioner is that due to some civil dispute between the petitioner and his younger brother, one day what happened, there was a civil dispute. One day when the victim was in the cow shed at night, this petitioner and his wife, both of them went there and they were chikkara आवाज सुनना informant went there and saw that television. Subsequently,
Because he is in custody since 13/5/2024.
13/5/2024.
And it is a case of 306, my lord. Where, my lord, the allegation is that there was a love affair between the petitioner and she was conceived, and thereafter this petitioner requested him to, my lord, terminate the pregnancy, and subsequently she committed suicide. This is the allegation, my lord. And there is nothing on record that I have instigated her to commit suicide, nothing of that sort, my lord.
The pregnancy because of you. Pregnancy is you were in relationship.
My lord, that is the allegation, my lord.
Now what is
The allegation is that, my lord, through me there was a pregnancy, and I requested her to, my lord, terminate the court,
and she.
and thereafter she committed suicide.
The petitioner actually had, he was called by the ED, and thereafter, my lord, once he said that I cannot come because I have corona, because of the corona problems. Thereafter, my lord, he had gone to Dubai. When he came back, they arrested, there was a lookout notice and he was arrested. Brought,
When did you go to Dubai?
after corona,
In between corona or what?
after corona.
After corona.
After corona, he had gone to Dubai. Thereafter, he was called. He responded to the my lords, and lookout notice was issued. Thereafter, he was arrested in Delhi airport and brought to Bhubaneswar.
What happened to the scheduled offense? Mal, schedule offences?
Scheduled offences, my lords, he's on bail. Vigilance case, he's on bail. And my lords, he has been called for interrogation by the ED authorities. Completed, my lords, charge sheet has been filed.
Now he's in custody.
Now he's in custody.
Yes, is flight risk is there.
Yes, my lord. Your lordship, I have last night, I have shown your lordship, kindly see page 22 of charge sheet, PC.
Yes.
That filed along with
Past conduct is all right, but
not past. I am not saying multiple summons were issued to him, my lord. He has not appeared. He fled away. He has wind up entire thing from India. Your lordship, kindly see his own statement at page 48.
48
of the PC, my lord. They filed along with a memo on 6/8/2024.
48. 48 of what?
48 of prosecution complaint filed by the ED.
Page 48 of this petition.
Page 48, my lord, they filed along with a memo. The PC they have filed on 6/8/2024.
48.
Paragraph 12.2.4.
Memo.
6/8/2024.
Memo. Reply you have filed. Where is memo?
Statement of
Memo. Memo. Flag D. Flag D. Flag D for Delhi. Flag E. Flag.
So it was filed on
6/8/24 we have filed.
Which flag? Let's see. Flag D.
Noting in sir.
Memo. Flag D. Okay. This is you file on 6/8.
6/8/2024.
Note it down. Flag D. Referring. Flag D. Yes.
Page 4.
Para?
12.2.4.
12.2.4. Read it out. Yes.
Your lordship may see from the first, my lord, it starts from page 45.
Yes.
45, 46, your lordship, kindly see.
You have not paginated also, that's the problem. Yes.
Below there is a page mark.
Yes, below there is a page. Statement of Sri Anand.
Yes, my lord. He is the
Anand Kumar Agarwal.
accused. Yes, my lord.
Yes.
He is stated as a director or managing director with Messrs. Siddharth Sponge and Power Limited and other different companies. That neither he nor his family members have any movable property in their name. That he has so and so. Then that Messrs. Siddharth Sponge and Power Limited is a company registered at ROC Bilaspur, Chhattisgarh. This company was taken over by him and Pratap Kumar Das, he is absconder, my lord.
Puri,
Odisha in the year to both of them were directors of the company since 2005 to 2009. This company, the business of raising of iron ore at so and so mines and trading of iron ore. In 2009, Pratap Kumar Das had resigned from the directorship of Messrs.
What is the relevancy of what?
Relevancy, my lord, I am showing you. Your lordship, kindly see how the money has been utilized. Then your lordship, kindly.
I am not deciding. I am not equating him.
My lord, there is a flying risk. The POC has not been seized. He has wind up everything. He has nothing in India.
You come to the point. You have arrested someone.
Yeah.
You have collected the document. You have filed the charge sheet. Everything is done. See, if you file all these things are the documentary evidences.
Yes.
You have to collect the documentary evidence. The only problem with you is he has fled away. He did not cooperate with you. As a result of which lookout notice was issued, subsequently he has been apprehended.
Yes.
Now you have to tell me whether there is a flight risk or we have to cap that. We have to see that he will not.
Yes, Lord, there is a flight risk.
Undertake, I will submit my passport.
Lord, there is a flight risk. He has wind up everything.
Tell me whatever
He will be required for interrogation.
he will be there.
Interrogation, Lord. So the POC has been, the POC has not. So kindly see one paragraph. Relevance shall show.
Yes.
48.
48.
Not only this offense, my lord, the loan amounting to more than 300 crore was adhered.
All right, but I am not impressed by this. I am only in the bail stage. I have to only see whether he will cooperate with the investigation or he will appear in the court.
He has not cooperated, my lord, during the investigation.
cooperated with the he has not only committed money scam here, he has availed a loan of 300 crore from public sector banks.
When will you complete the trial?
Now, he himself admit this Pratap Kumar, he is in contact with me, but I know about this man. He himself has admitted in his statement.
Now, how many years it will take for the conclusion of trial?
No, it's not the question. Now it's a preliminary stage now. Only who was arrested.
Tell me, how much time will you take for the purpose?
That I take because that's a directed me to.
I'll tell them to cooperate and finish him.
Your lordship has directed me to take instruction. That was in the Friday last hour. So I have to take instruction.
Very correct. I'm not saying. See, you can't keep him in eternity.
That's true.
The trial in these kind of cases, trial will take 10 years.
Now trial will not take 10 years.
Give a statement and record it and finish it up.
The lordship will only next week I'll take instruction.
You tell me, for the purpose of completion of investigation, how much time will you take? Second, trial you can't make any statement. Trial nobody knows what happened. And since 173(8) is open, you have to tell that. How much time will you take for Second is, if the flight risk is there, how will you restrict him not moving, and how he will cooperate with you in each and date appearing? You may say that he will come and appear before IO every Sunday or every 1 month or whatever. Restrict him because of his past conduct. But because of his past conduct, you can't change him.
Past conduct, he is in the radar of different.
You show me those that show me.
Your lordship call you next week. I will
put it next week. Let us focus in. Merit you need not know me. He is a worst guy, I know. I don't
radar of different investigative.
Those things you tell me.
I just give the contact, take instruction
and make sure that in all the cases he has to cooperate.
Yes, Lord.
Otherwise it will be cancelled.
Yes.
Cancellation of bail will be cancelled.
Yes.
And that apart, Malats, they are the highest investigating agency, Malats, with who under whose radar I fall is Delhi.
I don't know how many cases there.
That's why you went away from India to.
Had you been participated in the beginning, I understand. Would not have been there.
No, this would have been.
No property in India.
And you know what is happening nowadays.
Part of the charge sheet, he is some.
Yes. If I'll go in merit, then you may not do that. I will go into merit at all. I have to see that the investigation should be completed and you should cooperate and you are not going to leave this country.
Certainly.
And it may so happen, I may write that, and there are traffic. You will start moving application. I'll go for this. I'll go for. So you have to close unless the trial is over.
And one of my relations can become one of my guarantors in the bill. So
Those things he will decide.
he will decide.
Those things. Yes.
Next Tuesday, Malats.
I beg to pardon me, sir. Item number 54.
Sorry?
Item number 54. I am applying number, but may be taken up after petition.
No, who is for petition?
My lord, I am
Compromise matter.
compromise matter. I will place
What happened? Why these people are not there?
ଆଜି appear କରୁଛନ୍ତି ନୋଟିସ ଯାଇଥିଲା ଯେ appear
Yes.
interim order ଟା my lord continue କର
Yes.
Item 4.
interim order continue
Yes.
My lord, item 4, my senior Mr. Palit is on his legs. So
After
he will be coming after.
no, second password is not possible. List it up. Yes.
18.
Yes.
Today I'm depositing the evidence and affidavit, that is deposition copy of the witness, deposition copy of the witness.
You not filed.
And today I'm filing that and supplying a copy also.
What is the offense?
Offense is my lord, my lord. And earlier in the FI it was for 15. During then the disease, when the taking at the time of taking him to medical, the disease died, my lord. And the allegation is the disease was sustained injuries by the accused with a wooden plank, my lord. But there is also the circumstantial witness. Only the one eyewitness there who is the wife of the deceased, my lord. But if your lordship sees the deceased, the wife of the sole eyewitness deposition copy, my lord, she also contradicted her statement, my lord. If your lordship pays,
She has supported the prosecution or not?
Supported, my lord, if your lordship cross-examine. It is the fact that I have stated the above said fact before the police. And for
Come to para 2 first.
Para 2, madam.
My husband died about 1 year back.
died about
But on that morning, while I along with the husband were in the house, my son is in the intoxication state, started quarreling with my husband and also assaulted him in a wooden plank on his head, by which my husband sustained bleeding injury on his head, and I intimated my daughter also. It is a very specific allegation.
Then we'll have to turn to stage number 2, my lord.
Now, which para?
Which, my lord, that is para number 5. My
Yes.
son has assaulted my husband on the front side of my house near
Whatever, huh? When my husband fell down,
at about 12 p.m. while
assistant
with
to 2
assistant
person, my also another, we have taken the husband to hospital. Yes.
paragraph 6, my lord. It is a fact that I have came to the court on earlier occasion to give my statement, and on that day I have stated before the honorable magistrate that in the evening of the occurrence day, my husband fell down and became senseless on the front end of my house, and he sustained injury on his head. And when I came to see him, by that time he was already dead. He was already dead.
So I invited my daughter
She became senseless and fell down. And after that, with 2 persons, he shifted him to the they both shifted him to the deceased. I intimated my daughter and took my husband to the medical, where doctor declared him dead. But then
164 statement is recorded.
Hello, 164 statement, 161 statements, he has categorically stated that the deceased, that the present petitioner who is the person of the deceased, he has assaulted, and for that reason the father was died.
Yes.
And the 164 statement, my lord, she has narrated that she was deceased was fell down. For that reason he was died. In the cross examination, my lord, in the deposition, my lord, categorically stated that
164 is confronted.
164?
164 statement has been confronted, but 161 is not confronted.
Not.
Because 161, she has said the same thing.
And out of the seven out of the 7 who have examined, 3 witnessed on that is PW1, PW2,
Calculations
6923.
6923, my lord.
23, 16,
6923. And my lord, PM report is that due to injuries, there is 8 numbers of injuries.
Just read, like to read one line, my lord.
the fact that you have given a blow on the head of the father is being very
The
categorical.
fact that due to injury on his forehead, he died. But the injury that is, he was a serious fracture, my lord. My lord, at the time the
Para 5 of the cross examination, she reaffirms the statement made in the chief. That's the problem with you.
if you lordship said that my husband
And you have not put the suggestion also in 161. You have made that statement. There is no suggestion to that.
No suggestion, my lord.
No suggestion also. This is the quality of evidence. What to do?
like to read one line, my lord. That is, it is a fact that I have stated before the honorable magistrate.
Madam, I see, I'll tell you, she is an eyewitness to the occurrence. You have to read the evidence in entirety. She have made a statement in 161 statement, then 164, then in the court. In 164, he has categorically not said, but the fact that he fell down and all these things are there.
At
164 is same thing.
well, at that time,
Where is the suggestion? Where is the suggestion? There is no suggestion also.
the lordship may give short adjournment.
No, I will not. This is you are right.
So the said that
1 minute. Petitioner is agreed by the.
time.
I read it, madam. I read it everything. I don't take much time to read these things.
Short adjournment.
Why? They are recorded and the evidence is recorded on 20th of August.
Go to the 164 statement and let me let tomorrow.
Equity here.
Then you also may take it tomorrow. Yes, also may pass it tomorrow, my lord. I'm yes, take it tomorrow.
1 minute, madam. Listen to me. On February 2024, your bail application is rejected. Thereafter, from April 2024 to August 2024, all the witnesses are examined. I got
John, but you'll also take it tomorrow.
no, that.
Tomorrow, man, fix it tomorrow, man.
See, last time also you did the same thing.
Last time, see you again, I shall take it tomorrow.
You can't take the court like this, madam. According to your whims, you have got the certificate copy. Last time you showed that the evidences are recorded on that copy. Please give adjournment. Today you are coming with the evidence. I read the evidence.
Unanimous prayer, my lord, that petitioner removes.
You see, I will tell you. On February 2024, your application was rejected.
Since investigation is not.
Let me. Then you have a worst case. That time investigation was going on. Now evidence has been recorded. The trial court will not see these things. You don't have ability. I am recording all these things. Because all the evidences are recorded from 16th April 2024 to August 2024. August 2024. The trial court is looking to all the evidences. You have to remove the bail plea there. That is what I am giving you, that liberty to you. Right of petitioner is agreed by the order dated 2022-24, whereby his bail plea has been rejected. His bail plea has been rejected in the nascent stage when the evidence was not even, the trial was not even commenced. Meanwhile, from April 2024 up till August 2024, arrangement has 7 witnesses in exam. Out of the 7 witnesses, 3 witnesses have not supported the prosecution. However, the sole eyewitness that has been examined as PW7, she in her examination in chief, although made specific allegation against the petitioner, but her statement in the cross-examination, the evidence in the cross-examination is little shaky. Counsel for the petitioner by encashing the contradiction appearing in the evidence of PW7 seeks indulgence of this court and submits that he is entitled, his client is entitled to bail. I am not inclined to will not the petitioner read the case. However, petitioner is granted liberty to renew the bail before the trial court. If such bail is moved, same shall be considered on the basis of the evidence which has already come on record. With this observation, I have recorded your statement also.
Yes.
21. Yes.
21. Lordships, senior will verify the date of custody, Lordships. That's why case was passed over.
Yes.
What happened in case Miller? So he was inside jail in 14 Miller. First time in 24 he has filed the bail application. I have verified Miller. He has involved in 12 cases. In 9 cases Miller he has convicted me. That's why he has inside the bail.
He has never applied for bail in this case.
In this case, he inside Miller.
I have not approached this honorable High Court, Lordships.
Trial court, how many times you have?
Trial Court, Lordships, I have no instructions how much time he has been there.
If you don't approach the court for grant approval.
He has approached Lordships. This time also approached Lordships. Last
and you have been convicted in other cases.
Other cases I have been convicted. Appeal Lordships, I have been removed and bail Lordships.
appeal. High Court has been,
Yes.
What are the offences? What are the offences?
420 and 480.
I grant bail then now. Custody from?
custody your lordship since 27/10/2014.
27?
27/14.
14, right off. Petitioner is an accused, item number, which is that?
Item number 21 your lordship.
Petitioner is accused in FIR number so and so. Allegation against the petitioner. In this case, the petitioner, the FIR was registered on 29/1/2014, and charge sheet was filed in the year 2016.
Charge lordships 13 lordships 14. 14 lordships 27/2014. Sorry, charge sheet was filed on 4/3/2017.
4/3/2017.
Final charge sheet lords.
Petitioner has been in custody since 27/10/2014. The petitioner, however, it appears that he has not applied for bail before the trial court and trial court. And counsel for the state submits that the petitioner has, what is the antecedent? How many antecedents? 12 antecedents. In how many cases he was convicted?
8 cases he has convicted.
In 8 cases, he is already convicted. Then counsel for the petitioner submits that appeal against the conviction in all the cases where he was convicted are pending, wherein he had already been enlarged on bail. Enlargement. Be that as it may, the fact remains that the petitioner is in custody in the present case since for about more than 10 years.
10 years, Lord.
10 years, about 10 years. About 10 years. Regarding head to the period of custody, I'm inclined to petitioner on bail, granted bail, subject to verification of antecedent, blah blah. So,
My submission not record. He is the Odisha head of the company, Miller. Ramakrishna Electro Company Limited has collected money from the state. That will be recorded.
I'm not going to merit.
Your lordship,
antecedent and period of custody 10 years, I'm granting.
your lordships, antecedent is there, your lordships. That
Subject to verification.
that is there, your lordships knows. So that fact may be deleted out.
If you wanted in some other case, how?
No, I am not. Your lordships knows that 12 cases is there, your lordships. That's why I pay your lordships.
Subject to verification regarding subject to verification as to whether the petitioner is wanted in custody in any other case, the petition shall be granted. If you are wanted in some other case, then yes. 28. Subject to verification as to whether this is required, petition custody is required in any other case. The petition shall.
But lordships, in another case, lordships, trial is going on. Another case.
If you are needed custody there, then you will not be released. Yes. Next. 28.
Right. Before long, had this case, my lord directed the exact allegation against this petitioner, Tikilal Doria.
Yes.
Only allegation is a boss or a boss age. 370.
What
happened with my lordship? Other allegations are there.
Yes. Tell me.
Tikilal से दिल्ली सेठ को मारामारी काम वसूल करी बोली सबुबले कहूଥାଏ तेणु सेठ आम ऊपर अत्याचार कला थरे मते विभिन्न वीडियो करूची बोली कही धरी कटा मारामारी करी बुलाइला मते हाणी पीस करियो बोली दिलीप सेठ धमक देला जहाँ सहित कथा हला मालिक
read that part.
Yes, sir. आम समस्त को बुले बुले घासीराम हरिजन मूल बसा नहीं की गला एवं टिकलाल रे बाइक रे पछे पछे पीछा कला.
He is following.
सेठारे पहुंचे पर पुनी कंटा बांझी नहीं की गले सेठारे आमको टिकलाल टिकलाल सेठारे आमको टिकलाल रो भाउज ଭାଉଜର ସ୍ୱାମୀ ରମେଶ ବାଘ କଣ୍ଟାବାଞ୍ଜି ଠାରୁ ଆମକୁ ନେଇ ମତେ ପାଟନାରେ ସେଠାରୁ ମୁକୁଲ କଲା ଆମ୍ଭେ ଜାଣିନା ସିଏ ତ କହିଲା ଯେ କିଛି କଣ ଖାଇବାକୁ ଦେଇଛନ୍ତି ପାର୍ଟ 2 ଦିନ ଘାସ ବାଛିଲୁ ପରେ ଆମକୁ ଇଟା ତିଆରି କରିବାକୁ କହିଲା ଚାର୍ଜସିଟ୍ ଫାଇଲ ଡେଟ୍
15/5/2024.
15/5/524. You see there are other evidences.
I will read the structure of the victim 161 just.
Victim by
husband said that people are
victim. Yes.
ମୁଁ ଆଜି ଆପଣଙ୍କ ସାମ୍ନାରେ ଦେବା ମୋର
Relevant part you read. Don't read
ଆଜି ଆଜି ଆପଣଙ୍କ ସାମ୍ନାରେ ଦେବା ମୋର ମୌଖିକ ବୟାନ ଏକ ଯେ ଆଜକୁ 4 ମାସ ତଳେ ମୁଁ ମୋର ଚାଚା ପ୍ରେମ ବାଗ ଚନ୍ଦ୍ରିକା ବାଗ କୃଷ୍ଣା ବାଗ ଓ ଆମ ଗାଁ ପାଖ ଖାଲେପାରା ଗ୍ରାମରୁ ଅନ୍ୟ ଲୋକମାନେ ଆନ୍ଧ୍ର ଦଳପଟାକୁ କାମ କରିବା ପାଇଁ ଆସିଥିଲୁ। ଆମକୁ ଆମ ଜୁନାନୀ ଗ୍ରାମର ଘାସିରାମ ହରିଜନ ଓଡିଶା ଭିତରେ କାମ କରିବ ବୋଲି ଠକିକି ଆଣିଥିଲା। ସେ ଆମକୁ ରାୟଘରରୁ ବୋଲେରୋରେ ଆଣି ଛାଡ଼ିଲେ। ସେଠାରେ ଦିলীପ ସେଠ ଓ ଟିକେଲାଲ ଆମକୁ ପାଟଣା ବସରେ ବସାଇଦେଲେ।
Tiklal was also the side of the petitioner is agreed by the order dated 15/4/2024. There are whereby his bail application has been rejected. Subsequent thereto, on 15/5/2024, the charge sheet in the present case has been filed. In view of the changing circumstances, petitioner is given liberty to remove the bail plea before the trial court. If such bail plea is removed, sometime we can check on its merit on the basis of the evidence which is formed part of the charge sheet. Yes, next.
39.
No. They'll review the bail plea. Yes, sir. Charge sheet is filed so 40. Yes, next. 39.
May I please, Your Lordship?
Yes, sir.
498/404B/406.
Yes.
4M IPC, my lord. Charge sheet has been filed under those sections as well. It is 306. The postmortem report reveals that the asphyxia is a result of suicidal hanging. I am in custody since 25/2/2024.
Which you have not filed anything, FIR, nothing is
Sir, which bunch of documents?
Where?
Later on I have filed. Later on I have filed.
No, it's not there.
I have sent the copy on the state as well, sir.
No, these are e-filing you have filed. The case, the FIR number is also not there. In the order of rejection, FIR number is not there. Nothing is there.
That I will supply. My lord, may kindly look at this, page 14 and
there is nothing, sir.
A bunch of documents I have filed, Your Lordship.
It's not there. Filing you will not do unless you file it on the registry. The e-filing.
Your Lordship, look at it because I have given copies to him.
Without those things, yes.
2 documents, my lord, message.
You tell me what are they? Yes.
My lord, at page 14, the charge sheet. The congestion and asphyxia is a result of suicidal hanging.
Custody since
25/2. No, 23/4/24. No, 25/2/2024.
Yes.
Sir, charge sheet kotha koucho tame.
Charge sheet kotha koucho.
Charge sheet
sir kale kebe arrest custody.
Custody, madam. It's charge sheet file on 23/4/24, madam.
23/4. Okay. Yes. Yes.
Purchase day.
Yes, custody from purchase day. Yes.
My lord.
Your husband?
Yeah. Only, but there are against evidence.
Yes.
Allegation were there, my lord, that we had frequent quarrel. I am drinking heat and all that. I used to drink a lot. That is the allegation, and we were staying together. I had taken vehicle on loan, this auto, and running the family. I was separated from the family also, my parents, and this happened on allegation is that we had a quarrel on that day, and subsequently I went out or something, and she hanged herself.
Show me that you were not there at the time of.
I was not there.
You are not present. Do you have anything?
Yes, yes, I was not there, my lord.
Yes, sir.
That
Is there?
some investigation, my lord. My lord, the accused husband is a habitual drunkard, my lord, and spends all the earned money in drinking of alcohol, for which he cannot manage the expenditure of his family, as well as the monthly EMI of the auto rickshaw, my lord, for which he used to sell the jewelry of his wife for drinking of alcohol, which had been given to her by her parents. During her marriage, as the same type of situation rolled every day and every month, and gradually the jewelry of his wife also got filled, my lord. The family dispute arose between the couple, and subsequently the accused husband started torture to his wife, disease of the physically and mentally, and demanded more dowry to his wife, my lord. He demanded more money for it, and a car. He also demanded his son-in-law to give a gold chain, as they had given him gold chain during his marriage, my lord.
Date of incident you read, what happened?
My lord, date of incident, my lord. During the spot visit of the IOT, the one ligature, one maroon color sari was found in hanging position, being tied with iron bar to the asbestos, my lord. And the statement of the neighbors I am reading, my lord.
I just want to know whether at the time of hook hanging, whether he was present or not. She has hanged herself. There was an unpleasant marriage. He was drunkard and everything is all right. That is the reason she has taken extreme steps. She has taken herself, or he has participated there, or what? To that extent, I need.
That statement that is not there, my lord. But that
he says that he was not there.
I mean that during spot visit, one ligature, one ligature found in the hanging position with iron bar the house, and during investigation the accused husband also stated that while he returned to the house after being food for their dinner, he found his wife hanging.
Husband says, any evidence you have?
Statements are there, my lord. And the statement of the immediate neighbor, my lord, that Devashish Mahapatra, my lord, that 25/2/24 ଏହି ମୌଖିକ କାଣ୍ଡ 24/3/24 ସନ୍ଧ୍ୟା ସମୟରେ ମୋର ପଡିଶା ବିଜୟ ସେଠୀଙ୍କ ଘରେ କଣ ପାଟିତୁଣ୍ଡ ଶୁଭିଲା। ସକାଳେ ଶୁଣିବାକୁ ପାଇଲି ଯେ ବିଜୟ ସେଠୀଙ୍କ ସାନ ପୁଅ ଚନ୍ଦନ ସେଠୀ, ମାନେ ପିଟିସନର ଚନ୍ଦନ ସେଠୀ ତାଙ୍କ ସ୍ତ୍ରୀକୁ ମାରି ଦେଇଛି। ଚନ୍ଦନ ସେଠୀ ପ୍ରାୟ ସମୟ ମଦ ପିଇ ଆସି ତାର ସ୍ତ୍ରୀକୁ ମାରପିଟା କରନ୍ତି, ଅଧିକ ଯୌତୁକ, ସୁନା ଚେନ୍, କାର୍ ଟଙ୍କା ଇତ୍ୟାଦି ବାପ ଘରୁ ଆଣିବାକୁ ଦାବି କରନ୍ତି। ତାର ସ୍ତ୍ରୀଙ୍କର ଛୁଆ ପିଲା ହୋଇନଥିଲା ବୋଲି ଚନ୍ଦନ ସବୁବେଳେ ତାକୁ ଚନ୍ଦନ ତାର ବାପା ମାଆକୁ ଖାଇବାକୁ ଦିଏ ନାହିଁ ବୋଲି ତାର ବାପା ମା ବିଜୟ ସେଠୀ ଦୀର୍ଘ ଦିନ ହେଲାଣି ରାଧାକୃଷ୍ଣ ନଗରରେ ତା ସ୍ତ୍ରୀ ଧରି ରହୁଛି। ତାର ଖଣ୍ଡଗିରି ରିପୋର୍ଟର ରହୁଛନ୍ତି। ଚନ୍ଦନର ବଡ ଭାଇ ମଧ୍ୟ ତା ପିଲା ଛୁଆ ଧରି ଅଲଗା ରହୁଛି। ଷ୍ଟେଟମେଣ୍ଟ ମାର the neighbor statement, madam.
I am asking something neither he is able to
that might be what your violence. Enter
next week. Please come with something so that I can pass an order.
Sir, charge sheet
on the you made a sweeping remark saying that he was not there. I am asking you solely that.
Got your question, sir, Lordship. I have to answer that. My lord, after tomorrow.
Not day after tomorrow, next week.
Next week.
You should come with preparation, because see how hard it is for getting time, you know. Every minute is so important.
Yes, sir.
Yes. Next.
48. Initial paper was lodged by Lord. 3762N, 330, 385, 506, ABC and the certain statute violation judges. And 28/26/24, 3762N, 385, 506 and person custody since 23/4/2024 again. Due to law that has become the victim, the victim was more than 19 years.
Yes.
And both are living in a different places, my lord. 17 December Upasana Hotel, 2023.
Placing the 160 statement the victim.
Yes.
Rising out of a protest petition, my lord. Initially, the affair was lodged under section 363.
Yes.
As per the OP number 2, he has filed a petition before this honorable court to receive the investigation from the General Police to CBCID. Thereafter, it was registered under section 363/302. And the final form filed that it is a Thereafter, we will file the protest petition under section 302. Out of the 4 accused, my lord, already 3 accused has been granted bail by my lord, man.
Yes, I'm appealing for the informant, your lordship. My lordship, there is allegation against the president.
Local police investigated. Thereafter, it transferred to CBCID. Thereafter, the crime branch also investigated, filed a closure report. And under protest petition, this summon was issued to him. He is in custody since?
Since, my lord, on 17/5/2024.
17/5.
Sorry, 7/5/2024.
Sorry, 7/5/2024.
Lordship,
Requests have also been granted to him. Yes.
all the accused persons have been seen last time before the.
These are the oral evidences by you, but police has investigated, they found nothing. What to do?
And your lordship, the postmortem report also says that if this is a case of driving, your lordship, then nothing has been found.
No, yesterday not with me, Miller.
Yesterday, absolutely.
Closure report filing.
Closure report with, yesterday PM postmortem report that.
But see, the very fact that after investigation, closure report is filed. Protest petition, to what extent you can keep him?
3 witnesses are already been examined, Miller.
3 witnesses examined.
4 witnesses are examined. 2 not 2, yes.
2 not 2. 2 not 2. 2 not 2. Right now, petition. I am granting petition.
Petition never referred.
Why should you object? You are investigating, investigation found that nothing. Why should you? Objection is there. Prosecution case para 2 para 4 ginto. Tapre para 5 ginto. Para 6 ginto. Para 6 ginto. The co-accused persons have approved this court by filing BLA bill number 2742 of 2024. This court, by the order dated 4/9/2024, and last date them on bail. And counsel for the opposite party information vehemently opposed to the bail. However, regarding head to the fact that the petitioner is in custody since 7/5/2024, and the fact that the police after the investigation while the closure of the case, the petitioners were summoned only on the basis of the inquiry conducted under section 202 PRPP on a protest petition. I am inclined to adapt to this. Yes.
Next, my lord, is the arising out of same incident, 2 FIR were filed. Arising out of a single incident, 2 was died. 2 FIR filed by the 2 parents. Is also similar manner in the again the
same here also the same investigation closure report and all.
Same incident, 2 FIR. Same incident, 2 FIR. And the CBCID has given the final closure report.
I will be the yes. 51. 50 and 50 the same position.
This is an application for cancellation of bail, my lord.
Yes.
Lordship will be shocked to see how the builder has duped the innocent allottees as well as this honorable court since 2018. He is on bail. Your lordship may see the order dated order dated. This is 9/5/2018.
Okay.
2018.
Yes.
Passed in BLAPL number 793 of 2021 at page 21.
Page 21.
Yes,
Okay.
Annex 3.
Yes.
Just
This is what you are asking for.
Yes.
Recall of it.
Yes. Lordship may see the third paragraph.
It is submitted.
It is submitted by learned counsel for the petitioner that the meetings have been held between the investors and the petitioner on 2 different dates, wherein some terms of settlement have been reached and a joint affidavit has been filed, signed by the informant association, the investors and the petitioner, mentioning that the petitioner has agreed.
Now that the settlement has taken place, therefore granted the bail. There is,
Yes.
after bail, nothing is happening.
Nothing. And the judicial forums have also seen.
In 2018, he got the bail, giving an impression to the court that I am going to settle. And thereafter, after getting bail, release.
Yes, and your lordship may see the order sheet in the annex 8. Only one paragraph I'll show. Annexure 8, page 50.
In these kind of cases, therefore, the courts are on the interim bail. You pay the money and then you go out. What to do? And you many people.
And he's saying that if you come to my property, it will be a criminal trespass. He intimidating the allottees. That is page 57. He says that in that view of the matter, you as an individual owner, flat owner, your rights are limited to your respective flats subject to verification of claim of your flat and you're lettered to take over the
Problem is once they get bail, then
yes,
they're very
unfortunate.
issue notice to 1 week, 1 week per record. 1 week per record. And file the Commissioner Authority will let counsel for the petitioner submits that he will be filing requisite during the course of the day. File it.
Yes. So, course of the day
tomorrow, by tomorrow. What is the amount, by the way?
What amount would be the amount? It is somewhat 7 crores. Almost.
From you?
No, from the association. The entire 400 members of an association, 7 Hills Owners Association.
Who are you in that?
This is the secretary. Yes.
Of that association?
Yes. 400 units. They are not even habitable condition. This is not there.
A resolution is there in your favor?
Yes, yes.
It is the representative.
Yes, yes. So the registered society resolution is there.
But you are not the informant or anyone.
Yes. At that time, the association was not the informant. One of the allottees had filed the prosecution, the criminal case. The FIR was filed by one of the allottees, but it was contested by the association as a whole before this honorable court on behalf of the.
And those
that
you were there. Because otherwise what logo study you have? That's another question to be raised.
No, it was there. The association was there. That is why the meeting between
who was the informant in the FIR?
The FIR
impleading. You must be one of the LLTs.
Yes.
Impleading. Otherwise you will face technical.
Yes, I'll also.
You will say that who are you? It is between the informant and me, and who are you?
No,
it is not a PIL.
The bail was granted after the discussion between the affidavit between the association and the.
But at the instance of a third party, can a bail be recalled?
No,
if you are not in the informant in the case.
Yes, I understand your lordship's query, but here on the instance of the joint affidavit only bail was granted.
That is a different story.
Yes, I'll implead.
You impleading.
Manoj Kumar sir.
Yes. You implead him as a co-petitioner.
Yes, I will be
not respondent. Co-petitioner.
Co-petitions.
Mr. Counsel for the petitioner. Submit that he would be.
More persons are there, my lord.
He would be.
One of them I will implead.
He will be impleading one of the informant in the present case as a co-petitioner. As a co-petitioner. Let him do so. And get the vocal up now and
yes, ma'am. Yes. 2006 matter, my lord. CBI, the Union of India.
What will be recalling?
Nobody.
Your Lordship, the petition.
Yes. What do you want?
Your Lordship, wherein the petitioner has filed an IS 1700 of 20 for your Lordship for early hearing of the matter, which is on record today, your Lordship.
Sorry, what do you want?
Your Lordship, I'm appearing on behalf of Mr. Sarthak Nayak, counsel for CBI here, Your Lordship.
Yes, what do you want in this case?
Your Lordship, actually the petitioner has filed an IA in this case, Your Lordship, for early listing of the matter.
Early listing, it is already listing.
Yes,
Listed.
yes, Your Lordship.
This is after we get.
53. This my name may be deleted.
Name now deleted, yes. 53?
It will please not see. Actually, the open number 3 is not found out. The question is that I have either issued the check.
This is the last order, Lordship. This is the last order. Order is 47, subject to the 24.
There is an attempt for
Address is left.
address left. In this case, we can go to adjudicate the points before the
And cause for the petitioner seeks to withdraw this urge all these points before the court below. If he removes any application raising all these points, the same service on its merit by the court below. This liberty petition is disposed of. Yes, next.
First.
Yes. May.
Yes, Mr.
There is a breach of contract. The breach of contract taken to is shape of criminal case, my lord. Your Lordship stated come to page 22 of my brief.
22. Complaint, huh?
That is a contract between the present infant of petitioner. I have supplied the bricks. He has to pay the money to me outstanding. I have asked him for the same. They have asserted I have lost the affair. In order to counterblast that allegation, he has lost the affair. I am placing few lines before your Lordship prior to this. सत्तावटा समय विद्रोह शत्रुता को केंद्र करी they have entered and I have asked for money. That is the fact, my lord. It can be borne out from the agreement between both the present infant and the petitioner. And thereafter, my lord, I have lost the affair. All the offences as tribal by master 341, 294.
Investigation is complete. Investigation is complete.
Not yet complete.
Till investigation is completed.
Because, my lord,
earlier also, my lord, one of the anticipated has been rejected. That has not been reflected.
That you have also not disclosed.
Anticipatory, that is there. But that is only my prayer before Lordship. Citibank can be called up. Seventh accept nothing.
No, why? See, investigation is going on. Why should I interfere at this stage? Because the FIR is registered as a cross, as a counter blast.
It's a color version has been given because agreement is there.
See, color version only, they'll have to see what kind of color is that. Whether it is black and white, what? The investigation is to be completed. At this stage, how can I interfere?
Because, my lord, I have annexed the document. Even though I am producing that document, investigation.
You produce all the documents before investigating agency, they will consider.
To that extent, you have to consider
which are the document you want to produce?
That is two series.
Two series.
Let
Mr. Das, counsel for the petitioner. In this petitioner is seeking quashing of the Fulwani PS case number 52 of 2023. The investigation is at the nascent stage. Mr. Das, learned counsel for the petitioner, submits that he has submits that the investigating agency is not fair not fair as the vital documents produced by him has not been considered. He had annexed two series, the present petition. He seeks to withdraw this petition with the liberty to place the entire document before the IO of the case. And IO of the case and IO of the case. If the petitioner produce the document before the IO of the case, the IO shall look into the document and deal with the same in accordance with law while preparing his report under section 173. 173. Yeah. While preparing the report, he has to take into consideration in accordance with this liberty, the petition.
56. Matter of 56, I am a petitioner. This is a disposable case. What are extension? I want to not stop.
No, we have not sought for extension time. The learned court below has asked for time. Will also dispose of with the time.
Maybe dispose of your matter. Okay, Sabu Malako Mariolini. Mother copy don't do I count. Why the extension of case?
If the court asks for extension, it is between the court and the trial court and
why this you go?
That is the reason. Whole difficulty is if you target the cases, the target is unreasonable target. You will file the objection to the report.
ମୋ ଜଣାଫଳ ବାକି ଅଛି ମତେ ବୟସ ହେଲାଣି 75 ବର୍ଷ କେସ୍ ହେଲାଣି 20-25 ବର୍ଷର କେସ୍ ଏଇଟା ମୁଁ ତ ମରିଯିବି ଆଉ କଣ ପାଇବି ଆଉ
The unreasonable target is fixed, then this is happening. Trial courts are also
ଗୋଟେ କପି ଦେବୁ ନା ନାଇଁ କୋଉ ଗ୍ରାଉଣ୍ଡରେ ସେ ଏକ୍ସଟେନସନ ନଉଛନ୍ତି
are entitled to controvert the report of the district judge.
ଆପଣ ହାଇକୋର୍ଟ ରୁଲ୍ସ ମୁଁ ଗୋଟେ କପି ପାଇବା ଦରକାର ଆଜି ପିଟିସନର ହଁ ଗୋଟେ କପି ଦିଅନ୍ତୁ
Object to it. Whether I give short or long. He is asking for 6 months. If I say 2 months, again it is unreasonable. And again you would move. This is the reason I gave indulgence, but
ସାବିତ କରିଯାଉଛି ମୁଦାଲା ଏକ୍ସକ୍ଲୁଡ୍ କରି ଜଣେ ମୁଦାଲା ବଞ୍ଚିଛି ଆଉ ଯଦି ଇଏ ବି ମରିଯିବ ତ ଦୁନିଆରେ କିଛି ନ ପାଇକିରି
this is the system right now. Pursuant to the this court wide order dated the 19/2/2024 directed the trial disposal for the case within a period of 3 months. 3 months. For the reasons stated in the 3 months, the learned special judge vigilance Vallasho has sought for extension while its letter dated 9/9/2024, which is placed before this court. Now, for the reasons stated in the application, the extension sought for by the lieutenant special judge vigilance is allowed by way of the last and final opportunity. 6 month time is granted to the court below to conclude the trial. With this observation, and conclude the trial. Yes, next.
This one. 57? Yes. My lord, your words may can be that to serve the notice because the last time it was not wrongly it has not been mentioned the date on what date he will appear.
Yes, notice you have served.
Notice was to serve, my lord.
Address is refused, therefore, through IIC.
Yes, that's what directed to serve personally.
I sent the notice to the IIC, but IIC want to know who they will appear before.
They're not mentioned in the letter.
The order dated 10/9/2024. The IIC Kendrapada police station was directed to serve notice on party number 2. However, the notice could not be served as a definite date was not indicated. Indicated date for let the IIC serve the opposite party.
Of the notice, but not
Serve the
date
notice,
given.
but fixing a date, which date? Intimating the opposite party, the date of hearing to be
Next date would.
seventh. Yes.
58. May I please? My lord, this mention against the order of the discharge of December 23. Yes. Special judge business capital.
Opposite party.
My lord, my lord, last occasion issue notice to the opposite party number 2 and the notice has been answered because he is not living there. Again, this state that opposite party number is not residing there.
You have to give fresh address then.
Yes, director, but age opposite party number 3 is just business of the state and I found one petition to believe that as already been here, opposite party number 1 and 2 for the Learning Council of the state and opposite means
Why is he included?
That's unnecessary.
Now he wants to drop the.
Why
have you included Inspector of Vigilance, Deputy Superintendent of Police, and who is Karunakar Panigre?
Who is an informant?
Why have you included so
not required by mistake. I just my petition I added.
How you moved an application to drop his name?
Madam.
The petitioner which application? Application is 56.
No, my lord. 729. 729. 56. 729.
Application number.
Yes, my lord. IN number 729.
Wait, there is no 729. Where is 729? There is no 729. Where is 729? Yes, 729. There is no flag, there is nothing.
Actually, I was already tried also.
There is an application.
729.
729, right on.
IN number 729.
Not flag, not index, nothing is there. Right on. Petitioner has moved this application to drop the to drop 2 and 3 or 2?
Only 3.
Or drop opposite party number 2 from the array of opposite party.
State is good enough.
They are served, no problem. But 3 is he's not able to serve 3. 6 2. Array of the respondent. Array of the respondent. For the reasons stated in the application, the same is allowed. Yes. The respondent number 3 is dropped from the area of the respondent. Yes. Yes. Now on merit.
Yes, my lord. My lord, on 31st December 2004, house has been searched. The petitioners number 1.
You are seeking passing.
Yes, ma'am. Discharge.
Yes.
House has been searched. Whether the charge has been filed or 5th July 2024. July 24. Charge has been filed. 26th is their date. Coming with one
case, you tell me.
My lord.
You are the wife, so you can't be prosecuted. That's
yes, my lord.
Yes.
One is right. Another, so, my lord, he has searched the house and his petitioner calculated
whether you have your own defense. What do you say?
Yes, ma'am. That is indicated in that synopsis note. Synopsis, first page of the petition. Synopsis, item number 10 notes.
10.
Yes, synopsis B.
It is amply submitted that. House of Stone Story.
56,000 received by the petition, but providing the ground floor of the petitioner's house, residing building situated as Jada Bajar Qatar, with effect on so and so minutes, the rate of 10,500 minutes.
Independent defense, you have to prove that.
Yes, my lord.
Yes.
He has calculated the disproportionate asset.
I am not here to calculate all these things, sir.
No, no. He has prepared, he has not taken into account 4,77,000.
All these things are tried. You have to, you have an independent defense, then you have to prove it.
And that apart, my lords,
You are not covered by that judgment.
another equal bench judgment is standing on his way, lords.
No, this honorable court also one passed the order, Ranjani Panda versus the state of Odisha. That
has been set aside, discipline.
He is the discharge.
So against that, state has moved the Supreme Court.
State moved to the Supreme Court.
Yes. That is set aside.
Rather, you verify this judgment. This stands on you, I think. You examine this one.
Okay. No, other date.
Okay.
And past, can be permitted to adjourn to the lower court, 26th date.
No. You don't have a case. I'm not willing to interfere in this matter. But still, since you are not ready, I am giving you next week immediately. You don't have a case at all. The problem is you don't have a case at all. Because you are not prepared, therefore I am giving you next week. Yes. Take that also. Take his judgment that Anjali Panda will that is set aside by the Supreme Court.
Yes. May I please your lordship, my lord? Let me complete first, my lord. This is my case, my lord.
You got it?
Final pension, my lord, no, final pension has not been given. My lord, with great respect, my lord.
What is this then?
My client signed the pension papers, my lord. I have served before the government, my lord, 30 years, my lord, 10 days. But they are showing that qualifying service of 1846 days, 5 years to not qualifying service.
What would be
that is your extraordinary judge. My lord, earlier they have shown before contact, my lord, before this honorable court, my lord.
Show me the order judgment which you wanted.
Yes, my lord.
Show me the order.
Yes, my lord. Kindly grant my contempt petition, my lord.
Yes.
I have annexed that document, my lord.
We can accept.
Para 1, my lord.
Annexed.
My lord.
We can accept. The order sought to be compliant.
No, it's not the content proceeding, my lord. No, wrong submission, my lord.
20 lakhs and earlier, my lord, near about 30 lakhs, my lord.
Show me the order.
Let me complete first. Why am I misguiding?
One, my lord, earlier, my lord, 1 lakh 34,000. 854 rupees, my lord, he has already.
My lord, running page 12, my lord. Kindly grant.
12. That is the order you want compliance?
Yes, my lord.
Yes.
That order is to be compliant.
12.
That is running page 12. Kindly grant to.
We can accept.
My lord.
We can accept.
My lord, annexure 1, my lord.
That is your representation. Annexure 1 is your representation.
You know, my lord, so far my content petition is concerned, my lord. I am reading the content petition, my lord.
I am also reading your content petition.
Yes, sir.
First annexure is the representation.
Number 1577C of 2005, my lord. In the result, the OA is allowed. Respondents are directed to.
Let me see which one. You say annexure 12.
Annexure 1, running page 17.
1 minute.
Petition, my lord.
And your content petition is here. It starts. 1 minute.
I filed content petition 8/10/2023, my lord.
Yes, 8/10/2023. This is
running page 17 of content petition.
Annexure 1 starts from page 10.
Yes, my lord.
Which is the representation?
Yes.
Okay. The first line is.
I am reading.
The Mati Bathanan.
I have a glass to reading page number 17, my lord. Running page 17, my lord.
12.
I have also quoted in para 1 of the environments, my lord.
14.
In para 1.
Yes. Come to 17.
Yes.
Yes.
The service of the petitioner with all consequential service benefits, including the areas of salary and retirement benefits. My lord, in the meantime, they have filed 3 complaints affidavit, my lord. In one compliance affidavit, they misguide this honorable court. That was so much content was dropped, my lord. There are two compliance affidavits they filed. That was also wrong. My lord, my lords, with great respect, my lord, my client has got some benefit, my lord. So far,
Man is present, my lord. He has got, my lord, near about, my lord, 3 lakhs, my lord.
I am not about
Thereafter, my last page, my lord, I have complained, my lord, I have given the area amount, my lord, area, my lord.
my reading, my lord,
1,800,000, my lord. So, if 1 lakh is saying you don't, please hold on.
Area, my lord, when the final pension.
No, see, 1 minute. It says regularize the services, one thing, and give the service benefit. Consequently.
Exactly, my lord. Unless until, my lord, they are not regular, how can we get the final pension, my lord? You have signed and.
So then you have regularized.
My lord.
Okay?
not regular.
And you have given consequential service benefit. The service benefit is this. This is the entitlement. That's what you want to see. What is your?
Yes, sir. My humble submission before the lordship is that, my lord, in para 1, I would mention so far as compliance affidavit is concerned, my lord. First, they have shown there are 7 years of extraordinarily, but I have served the government for 30 years, 10 days, my lord. 34 years, 10 days. But they are showing now, my lord, 5 years is extraordinary. That is, I have served the duty time was shown as extraordinary leave, my lord.
You have been regularized, obviously.
Not regular.
Therefore, you are getting pension. You have been brought to the pensionable service by regularizing you. Okay.
Yes,
Thereafter, the financial benefit, whatever is to be calculated, they have calculated it. The contempt court can't do all these things.
I filed the original application so far as the disciplinary proceeding is concerned, my lord. In disciplinary proceeding and the self-single, after 10 years, second disciplinary proceeding was initiated and the self-charge, my lord. That's why they dropped and that was exonerated, my lord. As per the order, thereafter the order of the honorable tribunal, my lord, they have directed to regularize my service. There are 7 stations are there, my lord. They have not completed 7 stations. After my lord's direction, they have completed only 3 to 4 stations and 3 stations.
Have you seen this now?
I have mentioned. They have let them find.
It is 12/9/2024.
I have filed a petition also, my lord, to their compliance affidavit objection. They have not answered, my lord.
I am talking about this. 12/9/2024, they have complied. You just give it us.
Yes, madam.
He can tell
The substantial compliance is still agreement.
My lord, with great respect, my lord, I humbly submit that. My lord, I have worked 34 years, my lord.
Don't understand.
Yes, ma'am.
This is not, according to them, they have complied. Have you gone through it? Without going through, why are you shouting?
My lord, let it come another day, my lord.
Then why are you shouting unnecessary? They have complied it, they are saying that they have complied. If you read it, if it is not, still anything is left, you address.
My lord, there are so many things are
same story every day you are shouting.
My lord, with great respect, I humbly submit before your lord.
Who shouts, in the court?
My lord.
A person who doesn't have a case, he shouts.
My lord, I have a case, my lord. I will satisfy my lord, my lord.
Without reading, you will satisfy. Read the compliance, read it.
Client and the state council and also.
I'll just record it. You have complied and let him go through, let him be satisfied. I'll place it immediately after vacation. Just seek instruction from your client whether still anything is left.
With great respect.
Mr. Ragada, the counsel for the state has placed on record the compliance placed on record the order dated 12/9/2024 whereby the petitioner whereby you have given the what
Forwarding pension paper, final pension to the AG.
Whereby the final pension approval and retirement benefit has been extended to the petitioner. Let counsel for the petitioner submits that he would examine the same and file objection if any. Left.
Only
If-
one online.
Objection if any, leaves the matter immediately after vacation. Okay.
My lord, one line may be added, only one request, simple request, my lord. File an objection, they should do verify. Only that one.
Next item.
Objection.
Next item. 60. Yes.
Item 16. I'm appearing for the petitioner in the first case, CRLMC, and the second case, criminal division number 216 of 2017.
Which case? Second one.
First case, my lord, CRLMC 974 of 2017, filed by me. Second case, my lord, criminal division number 216 of 2017, that has also been filed by me.
Yes.
And the third case, criminal division number 284 of 2017, that has been filed by my learned senior's client, my lord. Well, today morning itself, my learned senior has served me a additional affidavit, my lord, in criminal division number 284 of 2017. My lord, ideally, my lord, there are certain points which he has taken, I should take time to let this find out. So, subject to whatever my learned senior says, my lord, still wants that hearing should take because he has taken some additional points, my lord. So, what would deal with that? No, my lord, today morning, let it be known. Let it be known.
I have not filed so far in court. Only I have served the copy.
Then, in that case, let it be ignored. No problem. No.
Then, item 60.
My lord, let me place the
Item
CRLMC number.
CRLMC.
CRLMC number 974 of 2017.
You are going to address there, that petition?
My lord?
You are going to address that petition?
Yes.
No, but before I address my lord, my submission is, your lordship, my case is 284 of 2017.
That has been filed last.
284, yes. This is what I have filed, passing the cognizance. If I succeed there, then the first one filed by him, CRLMC, will not survive. Because in CRLMC it said that my two cases under 138 be taken to his complaint case under the IPC and be tried together. Analogous. Alleging that both are counter case. So if I succeed in my case, then question of hearing the first one, right? So I may be. Let us proceed to that case. Yes. But all these things are arising out of the same
incident.
Facts.
Same incident.
Yes. Not same incident. Instance maybe.
I can demonstrate from the pleadings itself that why it's on the same incident.
Yes.
Let my learned senior address first.
Yes.
May I please your lordship?
Yes. You are addressing 284.
Yes, 284.
Yes.
Here I have filed the present case for quashing the order of cognizance.
Yes.
That is dated 28 2017.
28 to
2017. Annexure 5. Annexure 5, my lord. Page 28. And cognizance has been taken.
Page 28, huh?
Page 28.
Yes. Yes.
Lordship, what is the lordship kindly see the impugned order of cognizance dated 22 page 35. Now,
yes.
Cognizance has been taken under section 406. Lordship kindly see to the bottom, my lord.
Yes.
That paragraph.
Yes.
Page 406, 409, 420, 468, 471 by 34 IPC against myself and two others.
Vrindavan Naik.
I'm Vrindavan Naik.
Monopolistic.
Durga Monopolitics and SR Refractics represented by such and such. They are not before a lordship.
You are Vrindavan Naik.
Yes, I am Vrindavan Naik.
Yes.
Now the cognizance is taken under this. Now fact of the case is like this, my lord. Fact remains the complainant, company, opposite party before a lordship, deals in preparation of homes in stock. And in order to purchase the share, I advanced 2 crores of rupees by taking bank loan by RTGS. Out of that, he supplied some homes in stock. Then outstanding remain 1 crore 96 lakhs some odd. That is admitted. I will take your lordship, that is admitted. But and he first issued
MOU was entered into. As per the MOU, I had to supply number 1 for GST. So far my purchase is concerned. Accordingly, on his request, I supplied. But he did not present the said form before the GST, alleging that to avoid my payment, that there is some defect. I will take a lawsuit to that. Then, my lord, he filed the complaint on the ground, so many grounds, that he was taken to police station, there was assaulted, and there he was compelled to write the undertaking and handed over the 2 checks. And he filed the complaint. Your lordship will find from page. You have handed over 2 checks. He handed over 2 checks to me in police station. Now your lordship. That was is not done. His case. In which cognizance is taken. Your lordship can say now page 28. The complaint was filed on 25/9/2013. Yes. And cognizance is taken on 28/2/2017. Complaint filed on 25/9/2013. Yes. And cognizance is taken page 35 on 28/2/2017. 17, okay. 17. And now the complaint was filed. Your lordship can turn now to the complaint petition. Yes. That is annexure 1. Page, your lordship can turn to page 13. Yes, I'm there. The offences alleged. Page 13, my lord, serial number 5. Offence under 406, 409, 420, 460. Page 13, huh? Page 13. It starts from page 11. Annexure 1. Yes. I am placing your lordship from page 13. Yes. Page 13, my lord, serial number 5. Offence alleged 406, 409, 420, 468, 471 and other offences. Now cognizance is taken on the above 4, my lord. 5, my lord. Now in the complaint petition it is alleged that the lordship can turn to page 16 of the complaint petition. There is any exhaustive complaint? Yes. When a complaint petition, your lordship may kindly see from the top. Line after. Page 16. Page 16. Yes. It is not out of place to mention here that during the course of above business transaction, rupees 1,96,71,136 rupees such and such was due on the complainant, which was to be paid to the accused number 1. So this is admitted, my lord. Now your lordship may turn to. I need not place the entire, it will take long time. Your lordship may kindly turn to page 17 towards bottom. Paragraph H. Paragraph H towards bottom, my lord. 16. Your lordship got it, my lord. 17, huh? Yes. 17. Paragraph H. Yes. Accused number 1 had clearly stated that in course of scrutiny, the form number 1 declaration submitted by the accused number 1 in respect of cell transaction with the accused number 2, form number 1 issued on behalf of the accused number 2 and accused number 3, form number 1 submitting issued on behalf of the accused number 1 incomplete, and defective and suspicious. This is his allegation. Then, my lord, the lordship may kindly turn to next page, page 21, my lord. Paragraph I. Paragraph L, my lord. Paragraph L. Yes. 2 lines from the top of that paragraph. Accused number 1 has done some forgery in accused number 1 has done some forgery in issuance of the form number 1 to us, as he has no authority to issue such form. GST and Central Excise and Customs Act as per material was supplied by the complainant to accused number 3. It has been learned the other things are there. Now on this he took not to inquiry was conducted. Now your lordship may kindly turn to annexure 23, sorry, page 23, annexure 2. One Niranjan Sahu has given evidence. Yes. Your lordship may kindly see as per MOU. Third paragraph, my lord. Page 23.
23, annexure 2.
Yes.
As per MOU, Pradhan Industry will supply chrome Sinstar to Durga monopolies and SR factories. Vrindavan Naik has never called any office bearer of Durga monopoly and SR refractory. Then supplied materials first to Durga monopoly in 2010-11 and 2012 to SR factory. Vrindavan Naik had made certain advance payment to us. Durga monopoly comes under SEZ, special economic zone. There is tax exemption in case of suppliers to SEZ.
What do you want to say on this?
Here I want to say that there was a amount, and for that I have to supply the form number 1. That next paragraph, a lot mechanism.
Likewise, SR factories.
Next last paragraph. As per our MOU, accused number 1 has to provide us form number 1 to us. Lordship got it, my lord?
Yes.
That is the case. Then, my lord, next paragraph, next page.
Which you have not given.
I have given. That I will take it. I have given. They are saying it is. So I have committed forgery, misappropriation, everything.
Then your entire case is, if the case of the complainant is that non-supplying of form 1. In one hand say that non-supply, and the other hand they say that is defective, suspicious, blah blah blah.
Yes.
Then the fact remains that you have supplied, but it is defective.
Not defective. Not defective.
You say, but that is their case.
Yes, I am producing the record supplied by the GST department. Assistant Commissioner.
Then come to that straight away.
Nah.
Why there?
Now the
simple question is whether form 1 which you have supplied, which is stated to be defective,
yes,
was not defective because it was supplied by the GST department. You have given it.
Yes.
Why are you taking me here and there?
It requires because
no, it's not required. In a cognizant stage, I don't need to go into all these things.
Show me that understanding very fast. So,
show me the GST form.
Yes, no, I'm saying.
Form.
Your also can see the additional.
Show me form 1.
Yes, additional epidemic.
Yes. Where is that?
Form number 1, page 6, annexure 6.
Yes. Annexure 6.
Annexure 6.
Yes.
This is the form.
Where is the original one?
Or this is the original one is not. It is given to him.
Yes.
This is the form.
You have received this original one.
Yes, I will take your lordship. Yes, he has received. He has received.
I have verified it. These are the government of this thing. Signed by
I have
proprietary
affidavit signed in which
certified by the.
Okay.
Your lordship, then your lordship may kindly come to annexure 9, page 11 again. When they said it is defective, spurious, other things, I made a request to the department which supplied it. They have said, page 11, annexure 9, my lord.
Yes.
I am directed to refer to the letter cited above on the subject matter and to confirm that from number 1 numbers such and such to such were issued to Mr. Personal Minerals SEZ unit. You now compare with your lordship, annexure 6, same number.
Yes, I understood it. Yes. What is it?
Yes, my lord. But,
is these forms are manipulated?
Now, the sole ground on which my learned senior seeks quashing of the cognizance order is, my lord, he's saying that none of the offences are made out. My respectful submission would be that
That is 468, 471 and all. I think you show me.
Well, there are
Form 1.
yes, I'll come to that, my lord.
Form 1, then
There are two parts to the complaint petition. Yes. First, my lord, is regarding the dubious suspicious form I submitted by the petitioner, my lord. The second part, my lord, which is very important, is the police excesses which have been committed by in connivance with the petitioners, my lord, for forcing me to submit 2 checks. But I'll take my lord now. Now I'll take
the cognizance taken.
Cognizance has been
taken in now.
You would see.
That's the difficulty with
You would see.
Come to the cognizance order now.
Yes, my lord.
Come to the cognizance order, page 28.
Few lines, my lord, for that, my lord.
Come to
my lord.
Come to the cognizance order.
Yes, my lord.
At page 35.
206.
Yes.
That is criminal breach of trust, my lord.
Yes.
409. Criminal breach of trust by an agent, my lord.
Okay.
420 cheating, my lord. 468, 471 forgery, read with section 34.
Yes.
So, my lord, now, my lord, when the magistrate has taken cognizance, just a prima facie view, my lord, he can very well go and file a discharge petition. Let the magistrate examine. That's what I am praying for before your lordship. My prayer back in 2017, it was a very simple prayer, my lord. The allegation which stems out from one incident where I was taken to the police station. He was present in the police station. The IAC, the SI, they abused me, they assaulted me, they forced me to hand over 2 checks. Admittedly, a check of 1 crore and 96 odd lakhs was given to him as a security. That check was dishonored. Thereafter, my lord, in the police station, I take the governments in my complaint petition as well as the governments in their complaint petition. My lord would be satisfied that it stems out from one particular date. But can this excessive be committed? For now, once you have taken, yes, sir. What is the cognizance taken? The cognizance may be taken of certain wrong offences.
Why are you not challenging that cognizance order? Saying that this offense is, these offences are made out, but cognizance is not taken.
Ultimately, the magistrate at the stage of framing of charge also, he can very well decide which is the charge, which are the offences made out.
You have also come. Yes,
I would bow down, my lord, by simple because when the incidents occurred from the same date, my lord, my simple prayer was way back in 2017 to club the issues and to be tried jointly in view of the Supreme Court guidelines in Nathilal case, my lord. But right from day one, the stay order is there and it's been operating till date, my lord. Very well, my learned serious client could have considered the fact, yes, let both the cases proceed together. But now you lordship, let me presently that yes, my lord. Yes, my lord. Yes, my lord.
My lord, my address is on cognizance, not on
cognizance may be bad for certain offences, but it's not in
406.
And whether this dubious or not, my lord, I need to take insight, but that thing can be decided by the trial court, my lord. They can
remain that you are also not satisfied with the cognizance order.
I'll take my lord. That Nathilal case, your lordship, I kindly have the CRM. Yes, sir.
17, these cases are pending.
Simple, but it would have been now or by now. Very well, the entire case could have been completed. But can this police exercise be conducted, my lord?
Yes, which paragraph?
Lordship, in the first paragraph. We think that the same procedure to adopt in a matter like the present where
sorry,
Nathilal. Supreme is later, my lord.
Yes, yes.
We think that paragraph 3, my lord,
fair procedure.
We think that the fair procedure to adopt in a matter like the present where there are cross cases is to direct the same learned judge must try both the cross cases, one after the other. After recording of evidence in one case is completed, he must hear the arguments, but he must reserve the judgment. Thereafter, he must proceed to hear the cross case, and after recording all evidence, he must hear the arguments, but reserve the judgment in that case. And the same learned judge must thereafter dispose of both the matters by settling judgments together. Yes, my lord. Lordship, I kindly
proceed separately, but the judgment actually part to it.
Now, your lordship, for a moment, your lordship, I kindly see, your lordship, I kindly see the annexure 1 at page 30, my lord. What is my allegation?
Your petition.
In CRLMC. In CRLMC number 974 of 2000.
First, my case may be.
Let me come by.
I understand. I heard. I understood your point. I'm trying to understand what he wants.
Your lordship,
application for tagging. Yes, the matter.
Yes, which was turned down. No. Directly here. Directly, my parents. Not over here as the CRLMC minute, all the 3 cases are given.
Well, the revision and CRLMC is being heard together. Don't worry.
Yes, ma'am.
You try there.
But question is either now since since so much of time has been consumed, your lordship may decide. And I'm bound to ultimately whatever your lordship decides. Now your lordship may kindly see.
Interest petition, of course.
Yes, madam.
Yes.
Page 21 of my complaint.
Page 21.
Paragraph J.
Yes.
That on 8/9, may I got it?
Yes.
That on 8/9/2013, when the complainant returned from his village Paran at 3:20 p.m., Just when he reached at his residence, a PCR van during investigation number so-and-so came with two policemen and the accused number 5, that is the SI Malone, who has been also added as a party over here in this case here in MC. The accused number 5 directed him to go to Nayapalli police station immediately, as the accused number 4, that is the IOC Malone, wants to meet him. As per his direction, the complainant went to Nayapalli police station and intimated Niranjan Sahu, Arun Kumar Sahu, and Sanjay Kumar Swain.
These are the allegation you made in the complaint.
Yes.
Where is the 202 evidence? You show me this part. This part 202.
202 my marriage senior, he just
Yes,
read out that.
so from his paper.
Yes, sir. He just read out that.
What are the evidence 202? You might have said everything in the complaint, but unless in 202 statement.
Yes, sir.
That,
Yes, sir.
why cognizance should be taken on that? That is the reason the trial court has taken cognizance in the other offences, not the of.
You know, super from
202 see. What are the evidence?
That was in placing your lordship, my lord.
23, 25. Page 23, my lord.
Yes, I am there. 23 I read it. 24 come to 24. The portion which you read from your complaint.
Yes, sir.
You actually give me
24, my lord.
24, yes. Huge part.
Third paragraph, my lord, on 8/9/2013.
On that day.
Yes, my lord. At 3:45 p.m. at 4 p.m. the complainant called me on phone and called me to the Nayapalli police station, intimated me to Arun Kumar Sahu and Sanjay, and then we went to
Including that paragraph also.
Yes, my lord. Same.
On the date, the complaint gave two undated check of so and so,
Yes, sir.
and for encashment of security.
Directly under the threat, my lord, I've been asked to hand over. Maybe, my lord, I owe this money to him. But there is a procedure, my lord. That check which was given to them, it was a security check that was dishonored.
How many witnesses to examine? Niranjan Sahu one and this Arun Kumar Sahu.
Yes, my lord.
And another is Sanjay Kumar Swain.
So therefore, my lord, my respectful submission is, and you lordship would see their complaint petition. You lordship may kindly for a moment have the CRNMC. What does their complaint petition say, my lord? Where they've filed for initiation of the for dishonor of the check, my lord. You lordship may
Come to page 26.
26, my lord, yes.
Yes, Arun Kumar Sahu.
Yes.
He narrates this fact. What happened, what transpires in the police station.
Am I right, my lord? But what is
not only this, my lord, not only this, if you lordship
is not taken so far
that is not case. You will not challenge that. Not taking of cognizance.
That was at the time of framing of charge, my lord. The Lord magistrate can apply his mind and see whether this anything. And you lordship for a moment, my lord, their complaint petition. What do they say? You lordship have the CRNMC.
138 complaint.
138 complaint. At page 73. There are two complaints filed.
73.
73. 1CC case number 6557. 7.2 and 7.3, my lord. That on point 6, the accused entity so and so. My lord, at the bottom, for which the complainant lodged a written report of Nayapalli police station at 8/9/2013. But they lodged a written report. On the written report and called, there is no FIR. Rather, police exercises are done and I have been asked to hand over two checks. So that is my case, my lord. Arising out of the same date, that is 8/9/2013.
Reply to 138.
It's there. You see it there? Yes, my lord.
Show me.
Yes, my lord. Your lordship, can you see?
Yes, reply. I got it here. This is Pramod Kumar Mohanty.
Yes, my lord.
This is the 138 notice. Where is the reply? Yes. Sadanand Khitri.
Sadanand Khitri, my lord.
Yes.
Your lordship, I kindly turn to page 87. Right from the very beginning, I have consistently taken this plea, my lord. But the law has to take its
87. Page 87, para 7.
Yes, my lord.
Para 7 you said.
And now, my lord, the criminal division which I have filed.
This reply is dated. This reply is dated. Reply dated. Reply dated.
29/12/2013, my lord.
29?
At page 91.
29/12. The complaint filed on. Complaint filed on. Yes.
And now with the criminal division which I have filed, I have filed challenging the order wherein the learned magistrate has refused to take cognizance against the police officials for want of sanction alert. But I will not cite any judgment to that effect alert, but 197 is very clear that the allegation should be remotely connected with the official duty alert. Is it the official duty of the police when they are making an FIR not to register the FIR?
These are not the issue here. Why should you?
No. The other criminal division which I have filed, which is that is 216 of 2017. 216 of 2017, my lord.
See that the case is developed, he has make out a statement, try.
You sought for sanction which was refused.
Sanction refused, therefore he refuses to take cognizance against the. No, sir.
There was no sanction.
There was no sanction, for which reason magistrate refused to take cognizance against the.
If there is no sanction, what can?
But over here,
all these things have happened.
Over here, sanction would be required only when the incident is connected with his official duty. My respectful submission is, it is none of the business of the period. Now it transpired the entire thing has happened in the police station. Do they mean to say that they wanted to compromise in the police station? What the police has got to do with it? I was compelled to go. I was assaulted. I was forced to hand over the checks. So therefore, directly there is nexus, and this is not in discharge of their official duty. That is the respectful submission. And I do not. 197 is very clear that it should be remotely connected with his official duty. And there are catina of judgments to that effect, my lord. So therefore, my lord, I would humbly request that the entire three cases should be clubbed together and should be tried.
Now my submission is, my lord, on this.
Not three cases. Only two
cases. No, 3 cases. They have filed 2 complaint cases. My CRMC indicates.
Now my submission is, my lord, before to whether it can be the case, counter case, in 2-1cc case, my lord, for bouncing of check. 1cc number 6557 of 2013.
In the come to page 11, who are the police officers?
Lordship.
Anup Kumar Kanwar.
Yes, my lord. Anup Kumar Kanwar. I see, my lord.
Ganesh Pradhan and
Ganesh Pradhan. Whom my marriage senior Mr. Manas Chan is representing, my lord. Both of them.
Leave them.
Yes, my lord.
Now you can move for taking cognizance because they are retired.
No, they're still in service, my lord.
Yes. Okay.
Now my submission is, my lord, 2 complaint case. One is 1cc number 6557 of 2013. There, evidence from both sides closed, and it is posted for.
He relying on that judgment.
That has been followed subsequently.
Now, the next case is 75 of 2014. There, our side evidence is closed. Defense evidence at this verge of completion, they are reached. So, on these circumstances, both the cases, 3 cases cannot be targeted, clubbed together, because the proceedings under 130 are summary in nature, and it has no connection with the offence, cognizance of which taken, my lord. And now, furthermore, my lord, the citation was cited before your lordship is with regard to relating to offence under IPC, not in special act. It is under special act.
Yeah.
And that's why I take your lordship to the date of filing the complaint and date of cognizance.
Yes.
4 years till 2017.
So I have seen the dates.
Yes.
The relevant date is the complaint was filed in 2013.
Yes.
Okay. The 138 notice was issued and he has replied to that in 2016 or something.
So you not sure.
28 to 2007 cognizance taken.
Yes.
By that time, both the criminal cases, my lord, under 138 is progressed, lord.
But that is his specific defense. The outcome,
evidence, no such defense is there.
but in the outcome of the case, this case, cognizance, where cognizance is taken, has a direct relationship with.
My submission is humble submission. It is no direct. Your lordship can see. I had paid the money. on bank transfer incurring loan. And he has supplied 1 crore some odd, 1 crore 96 is due. Can I say that I was an agent 406 is applicable to me?
Right.
409 is applicable to me, my lord.
You're right.
And I have taken your, and 420 is applicable to me, my lord. And 468, 471.
Yes.
I have taken your lordship to the form.
You file this application.
Yes.
I am to.
But the second judgment which I am relying is that of Sibo Mishra. That has followed nothing.
Submission.
Yes, sir.
And insofar as that color of duty aspect is concerned, I'll separately deal with that.
I beg your pardon, madam.
That police officers,
Yes, sir.
whether it is coming under the color of duty or not.
That is why, madam.
Huh?
1 week time to find out.
Fine, 1 week time. Yes.
For the police officer, definitely without sanction
Cognizance is rightly not taken, but whether it is coming under the color of duty or not, he want to.
Yes, sir.
Yes.
But my submission in air my lord, 406, 409, 420, 468, 470, nothing to do with the police is concerned.
Yes.
34 they want to add, madam. For this, 34 concerned, there is no matter.
Ideally,
One of the offenses to be attacked.
ideally, he should have filed another petition challenging the cognizance order.
And further, my lord, my submission is.
I am happy with you.
Outside, it is
This office has been made out every time. I am happy.
your arsenal is appreciated. In addition to me, there are 2 other accused persons in his complaint petition. No notice has been served on them. And it will take not than 10 years to serve notice on them because they are outsiders.
At 2017, if they could have considered, let it be tried together, but it would have been over by now.
You are not filed any.
Is there any chance of reconciliation?
My lord, a company matter was pending before this honorable court. Order of attachment was issued. On the verge of that, it has been transferred to NCLT. Attachment was there, everything, my lord. My lord, officer was also appointed.
It can't be transferred. Somebody might have filed a section 7.
Yes.
Who has filed section 7?
Application was filed by.
Who has filed section 7?
From which side?
I was not doing that case, madam.
Must be some operational creditor. Must be some operational.
From each side.
You have set up some creditor.
I am only looking at this case, madam.
You might have set up some creditor.
Businessman, incurring loan, I have paid this and admitted amount is 1.
Why don't you? Is there any chance of settlement? Then
He's not prepared. He's not prepared. I am prepared, madam. Your lordship.
why don't you do it?
Madam, I'll find out, madam. Your lordship may kindly
Find out and take tomorrow.
let it come. Only for the, we'll file a, in case if there is no settlement, we'll file a note to that effect. We'll file a note.
And the ideal situation would be, see, in this situation, they will explore the possibility of settlement and do it, because see, you are suffering a insanity proceeding. Unless you have initiated that proceeding through setting up by a operational creditor or a financial creditor. Maybe some operational creditor.
Right, nothing, nobody is there.
I'll find out. When only when what I feel, he is agree with the fact that this thing had to happen.
Don't go into the many try. I have already.
2012, I paid them.
He's not.
Is the.
Why the police have to be involved for me
But it reach nowhere. This thing goes on.
I'll find out.
Find out and tell me.
You'll actually keep it
Immediately after vacation, it did good.
Okay.
For the purpose of getting instruction whether.
Hearing concluded, I will may also reserve the judgment.
Yes. Yes. Part heard. And
61.
May I please, your lordship? For the opposite party, pursuant to your lordship directions, the parties have appeared before the mediator. It's on record on 17/9/2024. The settlement has been arrived between the parties.
Very good.
They have stated, they will pay the balance 40 lakhs within 15th of December. First 10 lakhs by 30. That is the mode of payment has been reflected in the order.
Right.
So the next date has been posted to 4th of October before the learned mediator.
I'll disclose it up.
Lordship, my only prayer, my lord, is to be keep it pending. The entire amount is.
Why should we wait for entire? See, if he has given undertaking before this court, he has to do it. Otherwise, you will face the consequence.
Yes.
Yeah, lordship.
You have arrived at settlement.
Right.
And the dues has to be paid in a phased manner. Phased manner. He will pay. I'll make him bound by the mediation report and dispose it up. And if he will not comply, then you have a right to revive it.
Right.
Right to revive it. See, how many cases are there?
There are
1,
5
2,
cases.
3, 4 cases. All the 4 cases are disposed it up.
1 for 2, 1 for 3.
1 for 2 and of 2018 is there.
Sorry, I didn't follow you.
1 for 2 and of 2018 said LMC. Cases.
All the cases.
All these cases are similar in nature.
Between the same party.
Within the same party.
Parties are different.
Parties are different.
Common transaction, man.
Common transaction.
Paravatani was given to sell the land, they have sold it up. Check was issued by them.
Now, you have settled the dispute. In terms of the settlement, I'll dispose it up. If any party is not complying with the settlement terms, the other party has the right to revive it. Okay. Right. The persons to the order dated. Where is that order? The matter was taken up hearing on 12/9/2022. The matters, all the matters, matters were taken for hearing on 12/9/2022. The following order was passed. Pursuant to the above order, the parties have undertaken the mediation process. The High Court Mediation Center, by its report dated 7/9/2024, has placed on record the terms of settlement arrived at between the parties, which reads as under the terms of it mediation proceeding. 17/9/2024 पूरा लिख दो. How much you have paid by now? 40 lakhs.
No, 40 lakhs is yet to be paid.
That is paid then.
54 lakhs.
54 lakhs has already been paid, and it has been settled that only 40 lakhs to be paid.
Petitioners have agreed. Petitioners have agreed to make good the entire payment, which is the disputed in the entire disputed amount in a phased manner. Phased manner, and the first payment is to be made phased manner, which is enumerated in the mediation report. By taking into all the petitions are disposed of in terms of the mediation report, the parties are bound by the terms of mediation. It is made clear that if the petitioner fails to comply the terms of the settlement as reflected in the mediation report, the opposite party, number 2, no? Yes, opposite party is at liberty to revive the present case. Present cases with this reviving present cases, revive the criminal cases initiated by him against the petitions. With this observation, the petitions.
Opposite party only, sole opposite party.
Opposite party court.
Only one line to be added that they should give the possession of the property. That's it. They should not be part of the, they should not make disturbance to give the possession.
You also can revive your complaint. Yes.
Just like
all the files. The opposite party is also undertaken that after receiving the entire settled amount, he shall be hand over the position, peaceful position, peaceful physical position to the petitioners. To the petitioners. Yes. 62.
62, I am
all the petition dispute. Yes.
Item 62, I am seeking an adjournment. My learned senior has.
What? 61?
62, my lord.
Okay. Adjourn.
Next week, can you?
Not next week, December.
again,
I am for the informant.
I am the petition.
I am for the opposite.
I am the petition. Is the
Okay.
opposite party.
Do you have any objection?
No, I am the objection per se now, but can we take it early because tomorrow or day
After vacation,
Friday 5 तारीख में रखना हो
Mastering may not be
I'm
possible.
a government servant, my promotion is held up, also.
Immediately.
Year one mediation report is there.
Mediation is unsuccessful.
Mediation is unsuccessful.
Mediation is unsuccessful.
So immediately second day of 23rd.
And I also apologize for missing on the second call, item 4. I was on my legs. I could not make it. I was missing.
Okay,
Court may not take me on this.
yes. See, you can't take them next week, man. Next week is not possible, sir. I will accommodate you, but let us see, huh? You see, notice was not issued. Notice could not be served because of want of requisite.
No notice issued.
Right? Reasons on. Let's see.
Admission stage.
No, notice was issued, no? No, notice was never issued.
No.
No, for the opposite state is there. State is there, that is the reason. At request.
Somebody wants to counter of
64 also? Yes.
65.
Public. Yes, sir.
Receive the income tax matter. I think the proceeding on
That matter you were showing me yesterday, today. The other one, oh, this is not other one.
No, she said,
No, the other one.
What finish, but I will copy the question. But that is 150 is weekly.
Weekly.
Weekly,
It
150.
was directed to list tomorrow. Huh? I see in the weekly list there was a matter. Yesterday you mentioned and Mr. Rai mentioned. And at least I should have been informed that this matter is listed before some other bench.
Which one?
Matter is listed tomorrow in some other bench. You people argued partly. I discovered subsequently.
No, you have not done.
Yes.
Yesterday, the matter is postponed to tomorrow.
No, that's wrong. The matter is being heard by another bench and the matter is listed tomorrow, 25th. You people have not informed me and I heard that partly and listed for further hearing on 26th. Subsequently, I discovered that matter was being heard by another bench and matter is directed to be listed on 25th.
I'll verify lordship, but
This is completely kind of misleading. It's like pulling up some matter from some court and hearing. That kind of situation.
we are not doing this.
Mr. Rai is a senior counsel here and I believed it, and this is very unfair. You say that it's connected and all. You gave the number, I told the least it connected matter. Subsequently, I discovered that matter is being heard by some other bench. And a particular date is fixed, that is 25th. I partly heard and listed it on 26th. Dangerous it is.
I apologize for that, lordship.
You should have verified, you are appearing for the state, you should have told that, no, this matter is being heard by some other bench. I can't pull the matters from some other bench and start hearing.
No, lordship. I apologize for that.
And you should be parted and senior counsel is appearing. This is very difficult. We have to believe the counsel.
Yeah, lordship. I'll apologize and next time I'll verify the matter properly.
That's right, but whoever does it, then he loses the face value throughout life.
Yeah.
Whatever he will say, I'll start doubting now.
Yeah, great, lordship.
And he's shown me the order, then it is shocking for me in the morning. Give that number to them. Put that file. Give that number. No, give that number.
Then we see 2164.
2164, that same matter. The one which being heard, and I framed the question and I told you to address.
2163 and 2164, there are two matters.
Whatever, these matters are being heard by some other bench.
And
It's Simon question.
And the judgment which the other matter where judgments have been reserved, I'll look into it and I'll release it. I'll release it, recuse from hearing. Okay. I have dictated the judgment, but I'll recuse because of this conduct. At least it to be mentioned. Huh? I have dictated the orders and list it and recuse. Yes. If this is the conduct, why should I? Yes. Yes.
Now, this is, my case was covered, squarely covered by judgment of Dishonorable Court reported in 2024-95 OCR page 1413.
Yes.
Where my lord held that the petitioner.
Show me that judgment.
My lord, I am giving all the judgment, including my lord relied upon the judgment of the Honorable Jharkhand High Court, and that Jharkhand.
Same issue, I think.
That Jharkhand High Court order was challenged before the Honorable Supreme Court, and Supreme Court has dismissed.
This is my judgment.
Yeah, but Lordship, in this case, what he happened, he has approached for compounding, which was rejected. Yeah. Page number 40 also, the last.
Yes. Are you sure that this matter is not pending some other?
No.
Have you verified it?
I my it is in the
beginning. I think it is coming to your court also.
Yes.
I'm giving all time, including the judgment of the Jharkhand High Court and also Honorable Supreme Court, my lord. That is the last case.
Yes.
SLP diary number.
This financial year, which financial year?
2022 to 12-13.
22.
No, Lordship, financial year 2012-13.
Where is the show cause notice?
Yes. And cognizance was taken on.
Show cause notice, my lord, annexure 1. The cognizance was taken.
Where is your reply?
25 2017. I have already paid the interest along with the penal interest by annexure 2, page 17.
Yes.
Page 17.
Yes. Yes. Delay is for
2 to 9 months.
9 to
9. Yes, the same thing.
Yeah, but in this case, approach to the department for compounding.
That was not
That point may be noted, and whatever order your lordship may pass may be taken care of. That has not been attached with this petition.
Yes.
The order is
This is the rejection order, my lord. Paragraph 6.
Department is rejected.
Rejected.
Department obviously will reject.
And they launched the prosecution. They have
Therefore, they have rejected. Department rejected.
My prayer will be the remanded back to the CIT for compounding.
So why do you come to the court then? In view of this judgment, they should give a fresh consideration regarding compounding. Shall I say that in all the matters? So, all the matters, I will say that the parties will approach the CIT for compounding. In view of this judgment, the CIT will take the call. Instead of causing that can also be done.
That can be done.
You can apply the judgment and consider it and do it.
Yes.
No, what I'm proposing to do is let these cases be pending here. You apply to the CIT, not influenced by the fact that matters are pending. The CIT will apply his mind and decide the compounding. So if he compounds, it's all right. If you know he's not compounding, then I'll pass the order. In all the matters, I'll do.
Let's.
That's a good idea. That's a good idea. At least they will see the judgment and they take a call. Yes.
Interim order में भी counting.
Judgment pass. ठीक है. Yes. 66. उसके साथ देखो वो जो
Item 66, before starting my learned friend, I am the opposite party, sole opposite party. Let's say I want to take time to file objection because he did a domestic violence act. So unless until they have praying for quashing against the present petition, which is allegations.
The interim order is operating.
Let's say interim order operating so far the petition is concerned. Yes,
You have no problem.
so let's see that is the proceeding is going on. Let's see, but see that there is a few days back, 15 days back, the 23 application was disposed of. So nothing will happen in the 2 weeks.
We should after, yes, after application. Learn counsel for the opposite party seeks 1 week time to file objection.
But sure.
We should also interim order to continue. Yes.
Right.
May I please, Lordship? Well, item 67, my lord, I am in VC, my lord. Permitted to withdraw, my lord. Permitted to withdraw.
Withdraw, yes.
But you make any better application.
Please send a memo. Yes.
68. Oh,
Yes, sir.
I'm there for the unfortunate lady opposite party and the child nurse. And an interim order is nurse against me.
Operating against you.
Yes.
Who is for petitioner?
Mr. Senior Advocate, Mr. Solangi nurse against.
What is this matter about?
Nurse, as back as in year 2016-17, in a domestic violence proceeding nurse, and maintenance of 8,000 was passed nurse. The challenge in appeal confirmed. They came before the Supreme Court, it was confirmed. They also went to the Honorable Supreme Court where it was confirmed nurse. But interestingly, in the present petition, the Supreme Court order has not been mentioned at all, nurse. Thereafter, 2017 execution proceeding was initiated, nurse. And the 2000, it continued 2022. An order was passed, which is now under challenge before also in 2024 years. On the ground that now she has been engaged somewhere as an Hon'Ble worker, and the parents-in-law of the respondent number of opposite party number are several old parents, and so they should not be saddled with this amount. That was the ground taken now in this CLMC petition.
But here the petitioners are the
parents, because now the wife, daughter-in-law has filed this application for the legacy of her husband. She was the only son. He died. And she, thereafter,
these petitioners are 70 years and 64 years. They will earn money and give you to.
No, they got property from the That was the ground before the Supreme Court. Supreme Court confirmed the award. That has not been disclosed before lawsuits.
Where is that?
The lawsuit look at laws. They have given the judgments of the trial court, appellate court, and the sound court. They went up to Supreme Court.
Now you are engaged somehow.
I get to 7,500. They stated that I am a supervisor. Supervisor is a high post was getting 40,000. And 16-year-old girl is there now.
Now, where is that order dated 15/4/2019?
That is annexing one which is under challenge. If your lordships, there are so many orders that will pass, and they challenge that line 22 order, 15/9/22 order at page 9. In execution case of 161/2017.
Yes, this is the judgment.
Thereafter, so many orders were passed till 24. They did not challenge it. In now 24, they have come up with a new case that she has now been engaged as a
This is the principal judgment by which the award was made.
Exactly, yes.
And they went to Supreme Court and they lost it.
Right,
second finality.
Right now.
And execution of this has been filed by you.
No, exactly. I filed the execution.
In the execution, this order was passed.
Yes, on 2022.
Execution.
Yes.
Okay.
And they challenge that execution order in 2024. Even though thereafter 20 orders have been passed by the executing court.
I understand. Where is it? Put it tomorrow. You to tell me all this thing, huh?
Yes, please.
Because if the main order has become final,
right? What to do? And there are so many properties she has claimed from the legacy, not that from their own laws.
And they in the meantime sold away property.
And there is, you have a chance.
That was the ground before the trial court in appellate court and on Supreme Court also. That has been dealt with in before.
You have an issue or you are alone?
Doctor is also there, your 16-year-old.
Then
She is also sympathetic too. Even your, I am also said that wife is not tender. What about the doctor yours?
the grandchild of these two people. They have to pay. Okay. Yes. Yes. Exactly.
Exactly.
Will it be
Notice sufficient.
sufficient? Who is repeating next item 69?
I am applying
For any note.
notice of issue. Notice of issue makes sufficient. Nobody is applying.
Matrimonial.
No. This is a plot passing of thing.
Oh, the कितने मीटर है? तीन तो कल ही पढ़ने को spill over to tomorrow.
Item number 17 may kindly taken up after vacation, my lord.
17.
That is only 1 minute. That I.
I am for the petition in this case, my lord. I have every right to place this matter. As per
1 minute to allow or 1 minute to dismiss.
my chance for dismissal, my lord.
Only 10 minutes. 24 order matter.
Okay, she wants after vacation, let it be. Okay.
That is for passing of paper. Only this is pending.
There is no stay. There is no stay
No, my lord, there is nothing. No.
after vacation.
My lord.
Investigation is on.
After filing of charge sheet, he has filed that passing of paper, and earlier this court also disposed of a similar matter. Your lordship
My
requested.
lord, I filed affidavit before this.
Immediately after vacation.
My lord.
There is no case.
My lord.
Problem.
Much obliged.
Immediately don't mention.
My darling senior is there. Sorry,
Thank you.
What do you want?
In this order. In this order.
Before vacation, I am not taking up. Why?
Order was still the next day. I was playing.
I am not taking up. The next day is going on. If you
In the supplementary list of
no, it's very difficult to bring in supplementary. Then I'll take up after vacation. Note kar vacation. Before vacation, interim order. I am not taking up next date of hearing. If I'll take up, then no the question of interim order. If I'll take up the matter, then it has to be extended. If I'm not taking up, it is automatically extended. 69 also.
69. More 69. I'm holding for this matter only.
This hour, this is bound to happen. Any important mentioning? No. The remaining matter will be taken up.
72.
Yes, sir.
Notice has been issued, I have sought copy.
Yes, 22.
Let it come after vacation. By filing petition number 317, that should be considered.
Then
In the meantime,
I learned from it also. Take 72. 68 भी अपन को ना 68 टाइम पर सामने से करना
tomorrow, because see, in that matter, you have not told me that the principal order by which the maintenance was awarded, you challenge that in Supreme Court. Supreme Court has confirmed it. And this is an execution proceeding. What can I do? Maybe father-in-law only challenge. And after tomorrow it's all right. But you should have told me that the principal order has been upheld by the Supreme Court. Execution, it has to be executed. What to do? I can't alter it. For whatever may be the reason.
उसके लिए एग्जीक्यूशन प्रोसीडिंग
अच्छा 482 Supreme Court order. Whatever may be, what can I do? You should have told me that I have already challenged. It has attained finally. Why are you telling all these things? Whatever may be. Now it is upheld by the Supreme Court. What this court can do? This court only can do that. I can accommodate it so much. I'll dismiss it now. Day after tomorrow morning, 10 o'clock, it will be dismissed. Get ready.
Item 7, suppression of correct, that is the original.
Where have you said that you, this is, you are telling that in Supreme Court?
No.
Show me in your petition. SLP dismissed.
Revision dismissed.
अच्छा काइन कोई बात नहीं है different story. Yes. Day after tomorrow. Yes.